docket. Good morning. This is the New York City Board of Standards and Appeals public hearing for March 31st, 2015. We'll begin with the special order calendar decision items. Item number 1, 76-12BZ, 148 Norfolk Street, Brooklyn.
Richard Lobel of Sheldon Lobel PC for the applicant.
Good morning.
Morning.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Continued hearing items. Item number 2, 545-56BZ, 2001-2007 Williamsbridge Road, Bronx.
Good morning, Eric Palatnik.
Good morning. You wanted to adjourn this till next week?
Yes,
Is that
please.
correct? So you already made your submission?
Yes,
Okay. So then, well, there isn't a next week, really. It's the 14th is the next hearing?
of course, that'll be fine.
So April 14th, continued hearing.
Submission already made.
Thank you.
Okay, thank you.
Item number 3, 25-57BZ, 221-18 Merrick Boulevard, Queens.
Good morning. Todd Dale for the applicant.
Good morning.
I think there were, from review sessions, there were still questions about potential notes that the commissioners might want on the plans regarding the zoning lot, or?
I think, yeah, the only notes that we wanted was that the, just to indicate that the zoning lot can't be enlarged without board approval.
Sure.
And I think that was the only.
Okay.
And I just, had a question about, just to make sure that if you were going to open onto the zoning lot that, from that building, adjacent building, that did it properly and that is shown, or say, on the drawing somewhere that, there's no access to an additional zoning lot from the.
Sure. We can definitely put a note on the plan and submit those, and then agree to any condition the board wants to put in a resolution about the zoning lot
Right,
not being able to
okay.
change. That's
Right, I mean, in terms
Understandable.
of access to that other site, it would be
Sure.
by an easement as opposed to by a merging of the zoning lot.
Agreed.
Okay. Okay, so then, any other comments on this? Are there any speakers on this item? I think we can close.
Motion to close, Chair Perlmutter.
Aye.
Vice Chair Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
For
we can submit that plan tomorrow.
tomorrow,
So-
okay, so then we could have a decision on the 14th.
Okay, perfect. Thank you.
So tomorrow would be literally a submission, how about the 2nd, April 2nd? You can
We'll go crazy.
have. Okay.
New cases, item number 4, 1203-65BZ, 1929 Bruckner Boulevard, the Bronx.
Good morning, Josh Reinsmith for the applicant. This is an application to amend an existing special permit that allows the operation of an automotive service station within a C2 zoning district. From yesterday's review session, I understand there are a number of clarifying items that I'd like to run through, and then I'd be happy to answer any questions that you have. So one thing that was noted is that the prior grant proposed or required some planter boxes around at the back lot line. The property, or the current applicant purchased the property in 2010, well after this grant, didn't even know that these were required. However, pursuant to our current proposal, we are going to be actually putting an entire row of landscaping and evergreen trees along that rear lot line. There's also some graffiti on the wooden fence along that rear lot line that we're going to take care of, and we'll submit photographs of that. And as I mentioned, that stockade fence is wood. We will have the plans updated to include a note that that is a wood fence. There are currently some drop-off bins that I believe were noted for clothing. Those are going to be removed, and I'll submit photographs that they have in fact been removed. The signage chart had noted that there are certain signs that are proposed to be removed. We will remove all of those and submit photographs of that. In connection with signage compliance, typically in a C2 district, you're allowed 150 square feet of signage per street frontage with a maximum of 50 square feet for illuminated signage. However, the 73-211 special permit actually supersedes the signage regulations, and it allows a total of 150 square feet of signage for the zoning lot, and it allows that entire 150 to be illuminated. So I will submit a copy. I have the zoning section right here. I'll submit a copy of that with our submission.
Is that in compliance with the prior approved drawings? I mean, that reflected that?
I don't know what the prior approved drawings reflected. I know that they had approximately 125 square feet of signage. Currently, there is more, but when we remove the non-illuminated signs that are indicated on our current proposed plans, we will have 141 square feet of signage, which would be within
All illuminated?
all illuminated, yes. And that is permitted under 73-11.
Does that include that sign that I indicated yesterday on the northwest
It's a light post
corner?
sign, and then
Yeah, and it sort of faces Virginia, but not really, and
that sign
includes
is
that in there?
actually one of the ones that is coming down.
That's coming down.
Yes,
Okay.
and like I said, I will submit photographs of that. But again, this special permit section doesn't differentiate between the amount of signage per street frontage. It's actually for the zoning lot. And then there was a clarification on the number of parking spaces. There are 7 parking spaces along the eastern, or I'm sorry, 9 parking spaces along the eastern lot line, and then 7 parking spaces in the northwest corner. So there will be a total of 16. They will be entirely for the convenience store use. I'm not sure if we'll actually need that amount, but it is a rather large zoning lot, and we do have the space to provide them.
And you'll put numbers on the plan showing each one?
Yes.
Right now, it's just kind of...
Yeah, it just aggregates
1, 2,
them all,
3.
so no problem. And I think the last issue that I'm aware of had to deal with the curb cuts. There are some differences between what was previously approved and what's on the existing and proposed plans. I'm not sure about why the curb cuts are actually smaller, or some of them are smaller than what was previously approved. But the curb cuts that are shown on our existing and proposed plans were actually verified by field measurements. And
So just cover that, I guess, in your facts and findings.
Sure.
I think you
Nope.
say everything is exactly the
Understood.
same, and it's not.
Okay.
So the planting, though, that will occur now, right?
We were proposing for it to be in connection with our construction because it does include us to rip up asphalt. And if we could wait a little longer before we actually plant trees along the rear lot line, just to ensure that we don't have any more frost that could potentially harm the trees.
Right.
We'd appreciate that.
Sure, but I think the problem was that landscaping was a condition to all of the prior grants and was never installed.
Well, I don't know if it was never installed. I know that the planting boxes are no longer there, and they haven't been there since we purchased the site. This is a new property owner, and we have that intention to put it there as soon as we have the approval.
So can you find out what the kind of the sequence of events is that needs to be pursued to do other kinds of work there? So, because I kind of don't see a good reason, I mean, end of April, actually frankly, middle of April is prime planting season. So that's only 2 weeks from now, right? As hard as it is to believe given today's temperature. So that would mean that if we just waited till the end of April and you provided us with photographs showing the planting in place, everybody would get what they want.
Understood. I mean, we do want to be able to file and begin this process as quickly as possible at the Department of Buildings so that we can get our permits and get construction underway in the summer months.
So, but the construction is related to the conversion,
Yes.
right? Right. So, but in any event, you're going to need a couple of weeks to submit us photographs and all that stuff in the next hearing. It seems to me that you would be able to do the planting.
Okay.
The planting is not related to the construction, right? I mean, you have to
Yeah,
put
but we are going
asphalt.
to have to be there and ripping up asphalt, and I'm not sure if, I'd have to investigate whether we need a permit for that to actually
You
occur.
don't need a permit for that.
So,
Because instead of planting boxes, you're going to be installing trees in the ground, right? So why don't you give us kind of a timeline on how to do that? And Anybody else?
I just noticed, and I didn't pick this up until I just reread this, is the building 1,622 square feet,
Give me 1 second.
the whole building? I'm just asking because you, I guess under 1099, TPPN 1099, I think it's only selling space that you have to be under the 2,500
It's
square feet.
2,500, or I think 25% of the lot area maybe?
Yeah.
Whichever
and
is
I think
less.
say 1622 is, so it would be something less than 622, because I'm sure that you've got non-selling space in there. That's all, just being nitpicky, I guess.
So the entire building has 1,600 square feet of floor area,
I think it's a little bit more
and
than
it,
that.
I don't know if the selling space is actually specifically delineated, but I can have,
Yeah, just to follow the TPPN, right? So it would be your selling space, not the entire building.
So that would be to modify the statement of facts, really.
Right, yeah.
Okay. Okay. Anything else? Anybody else? Are there any speakers on this item? So, So one way to approach this is that you submit the responses quickly, and especially about the planting. But it seems to me that the most ideal way of working this would be that as soon as the landscaper says it's okay to put things in the ground, which I've been sort of taught is April, then you'd be done, right?
Okay.
And so we could vote this out like at the end of April.
okay.
So if you could submit, say, April 16th, images of everything that you've got in place,
Absolutely.
removed signs, ideally planting. If planning has to wait the following week, then submit the photographs the following week
Understood.
for a hearing on the 28th of April? Decision, sorry, decision on 28th.
I'm sorry, what was the decision date? The
28th of
28th.
April.
Okay, I think that'll work.
Okay, great. So for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Thank you.
Great, thank you very much.
Item number 5, 35-10BZ, 14511 77th Avenue, Queens.
Richard Lobel of Sheldon LaBelle PC for the applicant. Madam Chair, as you're aware, this is an amendment to an existing application as well as a request for a waiver of the rules. The original application was for a synagogue which was granted by the board in 2011. The applicant was given until 2012 to obtain a new C of O. They were unable to do so. I think a lot of the difficulty on behalf of the synagogue was that prior to this application, there was a private owner of the synagogue, which was transferred to the synagogue group. And now there's, with new executive officers, they're attempting to clear all the violations, and this is one of the reasons we're before the board. I'm actually joined today by Jenny Agbisa, the project architect, as well as Moshe Rafalov, who's an executive officer of the synagogue, so I know that there were some specific questions. The merits of the case remain the same, which is that the yard waivers and the parking waivers, as were requested, would remain unchanged. The front, side, and rear yards are as they were approved by the board in 2011, but there is a very difficult and tortured history as far as the attempts to obtain a certificate of occupancy and the violations on the building. Moshe has told me that they're currently discussing this with ECB, and there's a negotiation, and they've been told that the idea would be that they would pay off and settle all of the violations immediately prior to the issuance of the C of O, that should they do so earlier, that there was a threat that ECB was going to repeatedly come in and issue new violations. So they have been in discussions with ECB, and that's the latest as far as the settlement that they discussed. I'm happy to answer any specific questions, as I know that there were questions about egress and such, and Mr. Agbisa is happy to discuss those with the board.
Okay. I mean, obviously, it's true that the substance of the case is relatively minor.
Right.
But the substance of the situation, which is actually dangerous, there's
Right.
occupancy in violation of a vacate order, that's not minor.
Right.
So, yeah, so if we could talk to both the architect and the owner, that would be good. Maybe architect first?
Hi, good morning. My name is Junior Bisit. I'm the representative of the architect. I'm happy to answer your questions.
Okay, so can you tell us what you've been doing to work with the Department of Buildings to provide plans that they find satisfactory and that meet code?
To give you a view of these plans, we are the third applicant for this project. Right now, we just take over all the projects.
Oh, you just started? When?
No, before. We already submitted to the Department of Buildings all the, what is the actual construction there, and then they have their objection, and the objection was submitted to you before they give us the approval of the project.
The only objections that we received were the ones that have to do with this variance. So we don't know what the other objections are.
That's the objections, ma'am.
That's the only objection?
Yeah, we
What
answered-
about all of your egress and so on?
We already answered everything.
So you've responded in the drawings to all their egress requirements?
Yes,
What
ma'am.
about the handicap accessibility requirements?
We have the handicap also, ma'am.
How does that work? I'm not sure I understand. You have a ramp that goes to the
Yes,
first
ma'am.
floor, but what about the second and the third floor?
The second and the third floor, we put everything now in the first floor because of the penalties of the buildings. They don't have enough money, so all the handicap access will go only to the first floor.
But I don't understand that. It's a synagogue where men and women are separated and there's classrooms on the top floor. How could that possibly be equal?
We
Treatment.
discussed this one with the synagogue congregation, and then that's what they told me to just put this one on the first floor because of their budget problems.
That's not representing the actual use of the project. Sorry, we'll continue that with the property owner. So what actual physical work has to be done to the building to bring it up to code?
Right now, ma'am, there's already maybe 95% completion of the project.
There is,
The only-
even though there's a stop work order? How is it completed?
The
Does it
only
work?
minor works there is the exterior works and the cellar.
When was the work completed on bringing it up to code? Is the ramp installed?
The ramp is installed, ma'am.
Ramp is installed and those other changes to the staircases and the porch were already done?
Yes, ma'am.
Even though we didn't have approval to do that in BSA?
The basic, that is according to the first approval of the approved drawings of the BSA.
Sorry, I thought you have to make changes to the egress, to the ramp, to the back porch in order to comply with code. BSA didn't know about those things. Sorry, when were you engaged as the architect?
2014 or late 2013.
And have you been involved in site supervision for construction?
Yes, ma'am.
Are you aware there's a stop work order on the project?
Yes, ma'am. We asked Department of Buildings to come there, and then they inspected this one.
So there's an undocumented partial lift so that you could do this work?
We have some communication with Department of Buildings, ma'am. We could provide you with the letters.
Yes, please.
But not everything's been finished because the
No,
the
ma'am.
front entryway has not been changed
No, ma'am,
yet.
not
Okay.
changes yet, ma'am. It's still at the same. We have the picture.
Right.
You want to give us the picture? We could provide you pictures.
So the front steps haven't been changed,
No, ma'am.
but the ramp on the side has been installed.
We installed this one, ma'am. Yes, ma'am. And
Okay,
then
yes,
we
need to
installed,
s- we-
and the Department of Buildings give us a permission also to install the drywalls.
To install the
The drywalls.
drywall?
Yes, ma'am.
What kind of a stop work order is that exactly?
Did you do any interior work? Have you done the
No,
additional
ma'am, no.
stair?
No, ma'am. We
Two
don't
stairs,
do
I'm
any
guessing.
interior works, ma'am.
Oh, so this is
Whatever-
only site work?
Yes, ma'am.
And I'm not sure whether or not you've actually installed the rear deck in the way.
No, ma'am,
No,
there's
you
no.
haven't, right? And
We have the pictures, ma'am.
Yeah,
if
and
you want.
the ramp that you have modified, it hasn't been installed either. Unless when I was there, I didn't see it, but,
A little confused about what was done.
yeah.
Can you please clarify, Mr. Lobel, what was actually
Sure.
done?
You know, we have a set of plans which are shaded to show the proposed modifications which would be required to bring them into compliance. I think what we'd like to do is just, in a submission, detail to the board the work that was performed, give the board the correspondence with DOB, because DOB has been extremely involved in this site due to the complications in the past. So we can provide that correspondence and maybe give a little bit of a clear outline of, you know, what work was done and what's required to complete the application.
Okay.
Yeah, that would be helpful, because I was confused as to exactly what kind of work DOB had asked you to do, because I didn't see any, any paperwork to
Sure.
deal with what was, incorrect code-wise.
Right.
So if we could perhaps, maybe get the objection so that we can check it against the work, the additional work that
Sure.
needed to be done, and then delineate for us, take us through it, that, didn't have enough egress or whatever it was, and so therefore, because I had a problem with your statement that you were in substantial compliance.
Yeah, I
Just as
think
a
that
statement.
right, no, I think it was in substantial compliance with the zoning waivers that were granted in the first application. I think the code issues are something a little bit different, which we would demonstrate to the board.
And I don't think we received copies of the approved DOB plans, because it sounds like DOB has agreed to the proposed changes, and we've never seen that. We've only seen separate drawings of proposed conditions.
That's fine.
So we-
We'll submit a set of those as well.
With regards to egress, ma'am, we have
Say by the mic.
Sorry.
with regards to egress, ma'am, we have a side egress, we have two back egress.
Yeah, no, I got the plans, but I think if we can get the DOB approved revision, right, so that we can see the DOB approved
Yeah.
your own design revision.
I have only, ma'am,
That's
the
it.
comments, the objection of the plans.
And give us the full list of objections so that we can just check it
can-
against what you've done.
Because Department of Buildings, ma'am, does not approve these drawings yet.
Right.
Only objections. I have all the
But they
objections.
they signed on the objection sheet.
Yes,
that
ma'am.
They're signing off. So
Yeah.
we want to see the drawings that they looked at.
I
and
will
the
give you a
objection
copy.
sheet. Okay, that's
I will
great.
give you a copy of the
Perfect. Okay. Okay, you have a question?
Yes, could you talk about the cellar and the new kitchen that you're putting in and the multipurpose area? And this is more for Mr. Lobel. And talk about the program that you have anticipated for that space.
Well, it's accessory space for functions within the synagogue. As with many of these houses of worship, there are accessory functions that take place within the synagogue, not involving outside catering, but for members of the synagogue.
So
So,
it's only for congregants,
correct,
basically.
correct. Yeah. Would not operate as a use group 9 catering facility as the board usually conditions these.
Right.
And you'll put
That-
that on the drawing, right?
Yes.
And on the C of O.
Sure.
Okay. I do have another question for the architect. The public assembly permit, have you already filed with DOB to get a PAA?
The public assembly, ma'am, if after they give the CO, we will apply for the public assembly.
After they get the CO?
Yeah, but it is indicated in the plan.
That you're going to apply for a
Yeah,
PAA?
everything that is more than 75 seats, you have to apply for the
Right.
public assembly.
But has DOB already reviewed this as a public assembly area in terms of egress and emergency lighting and
Yes, ma'am.
sprinklers, et cetera, et
Yes,
cetera?
ma'am. Yes, ma'am.
So-
Actually, the Department of Buildings, they have to review the plans, and then there is another department that will review for all the, the lights, the egress, everything.
Right, so there's another department, so what we really need you to do, see, the problem here is the building has been illegally occupied for a long time, really illegal. And as a public assembly, a place of assembly, it's incredibly scary, the idea that it doesn't have the required egress and all of that. And so what I would like, I know it's an unusual order of things, but you need to have the department, what's the group that actually reviews the PAAs? What, is that a separate? It's just a part of the part of DOB. So then we'd like you to have that Department of Buildings review your public assembly arrangement and make sure that what you're proposing to do meets their requirements now. If the only
Everything
thing-
is in the plan now.
Sorry, no, I know that, but we need you to meet with that department, okay? And get a sign off from them that it meets their requirements. We need you to do that now. Not in the future, not after you get a C of O, because we don't know when that's going to be exactly. But this is a very, very dangerous situation right now. Okay. I'd also like to speak to the owner.
Hi. I'm not the owner, but I'm here representing
What's your name for the record?
my name is Moisey Rafailov.
Okay. You represent,
I guess you could call the executive board. I represent them. There's a substantial language barrier, and it's been like that for many years until recently when we were, I would say since we went to the community board, that is when the youth became more involved in the actual issues of the shul, which we weren't fully aware of. The executive board may have been, but we ourselves were not. So I'm here.
so do you attend the meetings, though?
Yes.
Okay, so you know what goes on, what people are thinking about, how it's operating.
Yes.
So the first thing I want to know is, on the second and third floor of this building, what goes on there?
Okay, so the second and third floor, we have women on the second floor. And the third floor, we have certain activities for the youth sometimes, nothing where, like it's just like prayers and things like that. If I may, in terms of the ramp, there was a question you had. The first floor, that's where usually the men pray. However, any woman that have difficulty even just walking up the stairs, they may be able to walk, but it's difficult. We have a section for them, a separate section that we can expand. We sort of use, it's called a mechitza. I can't explain, sort of like a curtain, and we can expand it as much as we need for the people. So anyone that's handicapped in a wheelchair, it's difficult for them to walk up the stairs to the second floor. That's where they would be. So in terms of the ramp, that's why the first floor, that's the main, I would say the main synagogue, that's the main place, and that's where they would be. But otherwise, anyone else that's able to walk up the stairs, they would go upstairs and utilize the second floor.
And what about the third floor?
The third floor, usually that's for, the youth are there.
So there's no such thing as a disabled youth?
There is such a thing, but there are youth downstairs as well.
How are there youth downstairs?
It's not just for older people, but it's...
No, but I thought what the purpose of upstairs is a study room. Isn't it for study or for play or?
No, we don't really play up there.
Okay, so study?
We do that as well downstairs. We have lectures and study going on downstairs as well. So you see, for example, on Saturday, on the Sabbath, we have prayers at 7:45 downstairs on the first floor and 8:45 on the third floor. So both of them have prayers going on and study going on. The rabbi gives a lecture upstairs, and there's another one going on downstairs as well.
Okay. And in terms of this whole story about illegally occupying this building, is a vacate order. A vacate order means the building is too dangerous to occupy, and it's being occupied. Why are you doing that?
So why we're doing it now, I would say, is initially the original owner, the person who was in charge of, I guess, putting up the shul, the synagogue, he didn't do it the right way. That's why we're here. And before we even had the permission to come in, and I remember this time, we didn't know, I personally myself didn't know that we weren't allowed to come in. And after such a long time of everything being hidden from the majority of the congregants, it was already occupied so much. It's like we used it for so long and we didn't know we weren't allowed to be there. And now it's just established. And
So, maybe this goes back to Mr. LaBelle, but just kind of a general, do you know if there's any kind of arrangement that's been made with the Department of Buildings? As far as we can tell, when we look online, you're in violation of a stop work order, and you're still continuing to work in violation of a stop work order, which is so surprising. And then you're in violation of a vacate order. And it still says it very boldly on the screen in very large letters, right? So unless you've made some arrangement with DOB, which wouldn't show up on the screen, you continue to be in violation of this legal order not to occupy because, God forbid, in the event of a fire, you don't have proper egress and people could die in your building. And I don't understand why you would want to take on that responsibility. So I'm having a lot of problems with this because without working out something with Department of Buildings, yeah.
I just wanted to mention the little that I know about this aspect of to answer your question partially. It was actually a cousin who's also a member of a young member of the synagogue. He went to the building department himself, and he spoke to one of the I'm not sure you call them, their officers or someone to help him with just to sort out exactly what we can do as members of the congregation. She told him that, as Mr. Lobel mentioned, that we don't have a C of O. So if the reason we have, if you notice, 25,000 and 35,000, those fines are for continued occupancy of the building, which we're not allowed to occupy. And each time they come, it's a $5,000 fine. So she said, you do not pay us anything now because once you pay us, we're supposed to come and check that everything has been fixed. Meaning if I say, okay, everything has been fixed or I'm paying you, they're going to reinvestigate and you still don't have a C of O. So we're going to fine you again, $5,000 because there will be people there. So she said, you should bring, that's what I was told, you should have the lawyer, the architect, the contractor, whoever it is, everyone come together. They must submit the paperwork. When you submit the paperwork, that's when you start filing, that's when you start paying. And initially you must pay the larger fines, which was the $60,000 that's there with the $25,000 and $35,000.
Okay, we'll work this out with Mr. Lobel. Okay, and then lastly, with respect to the kitchen and the cellar, you understand that this is not to be used for anything other than the functions for the synagogue, not to rent this out to anyone else. The size of the events has to be limited to the congregation, and it also has to be limited to the size of the public assembly permit, which I guess is 140-something people, right? Because you're reducing the size of that room. That's it, right? That will be stated on the certificate of occupancy, and you could be shut down if you use it as a catering facility. Understood?
Yeah.
Okay. Okay. Can we speak to Mr. Lobel, please?
The project architects just wanted to briefly address the vacate order and the fact that Department of Buildings has come in and inspected, and that there's been structural reports that have been submitted which have received sign-off, so that there's an understanding that despite the vacate order, that they can continue to occupy the synagogue. It's been problematic, but
I think you need a little bit more than just the conversation.
sure.
Right.
I mean, the vacate order, Department of Buildings does not vacate, especially a house of worship, lightly. So that would mean that they had a real concern that people are in imminent danger, right? So the thing of it is that even if you've had conversations
Right.
with DOB, I would be more comfortable seeing something actually in writing from DOB, preferably a lift of your vacate order. But I'm not sure you want anyone else to speak about this as opposed to being able to produce something
Fine, we'll submit.
in writing about it, right?
Actually, ma'am, the Department of Buildings asked us, when we had a meeting before, one of the deputy board commissioner, he's not there yet now in the Department of Buildings, Queens, he asked us to submit the engineer's report about the structural stability of the building. We could submit it this later also to you, certifying that the building is structurally sound to be used.
That's good, but they have not seen fit to remove your vacate.
Right.
Which to me tells me
Yes,
that there
ma'am.
was either a deficiency in what you've given to them, they could not approve it wholly, which means that I personally cannot consider occupying this structure without seeing that at least someone at the Department of Buildings, an inspector, somebody, has okayed this in writing and removed your vacate.
Right.
So a conversation is nice, but it doesn't, win the day,
Yes.
okay?
Okay.
Okay, so basically, yeah, speakers in a minute. Excuse me, sir, just a...
It's the fire department.
I'm sorry, your fire department, but just a second. So the issue is, of course, there's all this illegal stuff going on, and so we can't condone it.
Right.
We can't allow it. It's not the deal.
Understood.
Right? So either you have to submit materials that show that the Department of Buildings has in writing agreed to limited amounts of work that's going on, that the Department of Buildings has agreed to the scope of the work, because so far we don't have any idea whether they've agreed with this, that they've signed off on this ADA exclusion, which frankly sounds odd to me, et cetera. You have to go one by one. It's not anymore about the scope of the variance. It's about the scope of this incredibly illegal occupancy.
Okay.
And then we're going to reach out also to DOB's counsel about this to find out what's going
Okay.
on from our side, okay?
Sure.
And then, I'm sorry, yes, fire department, yes, please.
Morning, Chairperson, Commissioners. My name's John Yacovello. I'm with the Fire Department. I'm a project manager and engineer with the Fire Department. And listening to the dynamics of this case, I see that there's multifaceted issues here, from public assembly, egress, structure, plus the pending vacate order. We do have a public assembly unit. We can conduct inspections, when the vacate is lifted. If this board would want us to somehow communicate, conduct an on-site inspection, the fire
Yes.
department would be amenable to that, in order that we could be assured that we have adequate egress, structural stability of the contemplated structures. We have issues that are ongoing throughout the city with what we call lightweight construction. And structural integrity is a very important aspect of our job, especially from the standpoint of our Bureau of Operations. So I try to rest with this board if they want any feedback from the fire department in a
Yes.
timely fashion. We would be amenable to accommodate
That would be terrific.
that request based on the dynamics of what I've been hearing this morning on this particular case, since it is a new case that is now filed with the board, and this apparently will be pending. So if you need a time frame for this, or we could hold anything that we do in abeyance until such time that maybe the vacate is lifted.
No, I think it's appropriate for you to inspect now so we can get a better picture of things, especially, didn't even think about the structural integrity with respect to lightweight construction.
Yeah.
I understand this was a house before.
Yeah, well, we have a
So-
lot of issues with that.
Yeah.
We do this on a monthly basis. Everything is based on what we call economies of scale, where now there's, conventional construction is not always the way that either residents of a building use, they usually go with lightweight constructions. Open truss construction, laminated wood I-beams, and the like. So we get monthly reports to the Department of Buildings, and we send them out to our line units to be assured that everything is installation specific and that it's safe. And it's also reported within our database so that if indeed there is a problem and our Bureau of Operations, meaning our line units, are involved, it automatically comes up, caveat emptor, buyer beware, that there is a potential problem and that they have to adjust their firematics accordingly.
So if you could put this on your inspect as soon as possible and give us a report as soon as possible
Yeah,
list?
and I hear that the building is also occupied under a vacate,
Right.
so we do have a license plate, we have a place of public assembly, we also have a public assembly unit.
Yes, that would
in
be
the Bureau of
great.
Fire Prevention.
Yes.
I don't know if it could be a multifaceted inspection through our Bureau of Operations in conjunction with the Bureau of Fire Prevention, but I felt it incumbent upon myself to bring this board up to date where the fire department stands, within the whole picture of and the dynamics of what's
So the way that it
transpired.
works is then, so the Department of Buildings has a public assembly department,
we
and
also-
so do you?
Right.
Okay. And
have
you
an
look at
IT.
different issues?
We do mostly social clubs and all that, but still, I mean, it's an egress issue, it's a structural issue, you got to vacate pending on the building, and the building is presently occupied.
Right.
So we certainly don't want to put the occupants in harm's way, we don't want to put anybody in harm's way with it. So,
Okay, so maybe, is this, Tony, is this your?
This is Carlos.
Oh, Carlos, where's Carlos? I don't know. So anyway, we can have our project manager reach out to you and arrange. Right.
excuse me?
Give your cards.
I have a card.
Thanks.
Great. Appreciate this.
Okay, so I just felt that I needed to inform this board of, the circumstances, based on what I've heard, especially with the vacate and the being
And the
occupied.
current occupants.
As an aside from
Yes.
from the pending vacate at Department
Absolutely.
of Buildings.
Okay, we'll get in touch with you. Thank you so much. I
You're
do
welcome.
appreciate it. Okay. Are there any speakers on this item? No, okay. So, there's a huge task here. And
Yes,
the task is basically to bring this thing up to code
correct.
before we do anything else. right?
Yeah, I think that, sadly, I think that many of these issues have been ongoing since the building was converted in 2008. So I think at the time of the original grant in 2011, there were frequent conversations with the Department of Buildings because the board had similar concerns at the time. And so there was correspondence from DOB stating that despite the fact that there needed to be BSA action to legalize the zoning of the structure, that there was an understanding that the occupants could continue to utilize the synagogue. And it was actually around the time, as I remember, of the Jewish high holidays, so it was a stressful time in that they did not want to vacate the synagogue or house of worship during an important time in the religious ceremony. So I think that what we'll do is we'll discuss this with the management of the synagogue as well as the architect, and essentially at least get satisfaction from Department of Buildings about the existing state of affairs in the building, discuss what the existing objections are, because I know that we're in the process of answering those objections, and hopefully give the board comfort as we move towards koshering the building, so to speak.
Okay. Any other comments? It's just,
Well, it seems minor in comparison to everything else, but my comment yesterday was you should add it's in a residential
Sure.
neighborhood. You should have landscaping in the front. You've changed the original egress, which was originally straight
Correct.
down the front, and now you seem to have it all around, but you should be able to partition areas and have landscaping.
I understand. We'll note that on the plans.
Street trees, all
Sure.
that stuff.
okay. Okay, so we are ourselves going to be in touch with both the fire department and the Department of Buildings Council because we have to get our hands on what's really going on
Sure.
here, but you need to help us understand what that is and be as straightforward as possible, please, because the more you hide, the more we find out on our
without a
own,
doubt.
and then the angrier we get.
Understood.
And the slower the approval process is. So, to nobody's advantage, okay? So, I'm not sure. So we need a submission on the drawings that were submitted to DOB and that resulted in DOB signing off on some of the objections or most of the objections. We need the architect to reach out to the PAA unit at DOB and get the plans reviewed. And then we need you to really give us some paperwork
Right.
on DOB's agreement with your occupancy, I don't
Right.
know what. You're working without a permit despite all of those stop works and vacate orders and all of that. And we need a copy of all of the objections that were issued for the building.
Okay.
Okay. So would like to get this stuff sooner than later because this is a really dangerous situation. So you think you could get this to us by, say, the 9th of April?
Okay.
For the next hearing on the 21st of April.
Okay. Thank you, Commissioners. Madam Chair.
I wanted to add that, with inspections, please make sure that they can get access
sure.
to the property. I know that sometimes can be a problem. Let's make
Okay.
sure it isn't.
Thank you.
Fire department inspector, let's just let them come in.
No, we don't need time for fire department to be, they're just going to submit as soon as they have.
Yeah, but it's speed.
Okay.
I just
All right,
want them to
thank
make
you.
sure they have access.
That's really, wow.
You got John. You know John. Okay. You want John's card?
I just emailed.
Yeah, I know. He knows John. We know John for years.
Appeals calendar, decision items, item number 6, 12614A, 3153 Richmond Terrace.
Morning, Todd Dale for the applicant.
Good morning, and thanks for making those corrections on the drawings. For a motion to grant?
Chair Perlmutter,
Aye.
Vice Chair Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Thank you.
Item number 7, 14014A, 1016 East 13th Street, Brooklyn.
Todd Dale on behalf of the Office of Eric Platt.
Just checking. For a motion to grant?
Chair Perlmutter,
Aye.
Vice Chair Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Continued hearing items. Item number 8, 16612A, 638 East 11th Street, Manhattan. And item number 9, 10713A, 638 East 11th Street, Manhattan.
Morning, Madam Chair, Commissioners. I understand the board is inclined to mark this case and the companion vested rights case off the calendar. I had the opportunity after the exec session to speak with DOB and allay some of the concerns we had and to move forward on that. And in view of that, I think we're fine with marking this case off the calendar, looking forward to DOB's withdrawal after we've resolved all the outstanding issues.
Okay, that's great. Okay.
Madam Chair, may I ask you?
Yeah.
So I understand that there was a text amendment that occurred in 2004.
That's
What
correct.
was the status of the construction when the permit, when the text amendment came about?
Foundations were complete.
But you had not obtained the additional work.
Within 2 years of?
So the foundations were complete when the text changed.
Right.
And then within 2 years, did you complete construction?
Oh, I don't recall if you have.
So I think that's important. I think that's something that the board needs to know. If you did not, then your permit lapsed.
Mhm.
And you would need the vested right recognized by this board in order to keep your C of O. So I think that's something that hasn't been entirely clear.
Well, it hasn't been raised by anybody
Well,
up until this
I
point.
think it has been raised by DOB.
I don't think it has, Billy.
Is it?
Oh, it has? Okay, well, in that case, we'll address that.
Fact, to the board.
Okay.
This is something that you can stay off calendar and resolve your objections, but if you're going to need this board to recognize your vested right if you did not complete construction within 2 years of that amendment.
Okay.
Okay. Andrew? All right.
Morning, Madam Chair, Honorable Commissioners. Andrew Wallace, Assistant General Counsel, Department of Buildings. I did attend the review session yesterday, and I can certainly, if the board would like, an update on some of the progress on this application to date. Just first, I want to just clarify that the Owners Council has stated that all of the objections have been addressed. That's not completely correct at this time. There has been progress, but certain objections do remain. I can report, though, that within the last year, the applicant has shown revised plans that address two of the what the department considered very major objections regarding this, and that would be plans that would show the removal of the mezzanine from the community facility in the rear yard, as well as showing revised plans that will provide tenants from the community facility with two independent means of egress. So that has been shown on the plans. Also, most recently, as the Owners Council advised, the Manhattan Borough Commissioner did issue a ZRD1 determination regarding the medical offices in the existing rear yard. Now, I just want to clarify that this does not mean that the objection is removed at this time. It simply gives the applicant a way forward on work they need to do in order to amend plans to come back and have the objection removed. So the objection is still active at this time. Certainly, we appreciate the effort that has been made, and I think substantial effort has been made, but there is still a way to go on this. There's also issues of the occupancy of the building, and in fact, that the certificate of occupancy says that occupancy on the first floor of medical offices, and there's been a persistent problem with occupancy as residences, and the board has made a referral to the department on this. An inspection was recently completed, and I believe we did find that there is residential occupancy, and the department is reviewing this and will be for the appropriate next steps. Going forward, I think the department is just concerned about what the marking the matters off calendar means. We want to make sure that we're able to come back to you, when the applicant is has made all of their corrections.
Mm-hmm. Yeah, it's simply what happens is every single time you come, it gets marked as adjourned. For one, it's actually extremely time consuming for this board because we actually review the materials and then it's adjourned. And the other, and it doesn't look good that you're got dozens of adjournments. It's simply that when you're ready, you let us know and we'll calendar you to come back.
Okay, very good.
Okay.
And I think that would be, so the next step when the applicant has resolved these issues to come back and resolve the applicant's vested rights question.
Right.
Exactly.
I'll be happy to take any questions if there are any.
Madam Chair, I recommend that we get a submission on the issue of lapse, when it happened, what was the status of construction, all that. Because if they don't need a vested right from this board, then once they resolve the issues that were raised by the CO revocation matter, everything goes away.
Right.
But if they resolve the issues with respect to the CO revocation matter, but they lapsed, then this board needs to recognize that they vested.
Yeah, my understanding, I've been told, is that we didn't lapse. I can establish that.
So
I don't think that'll be an
submission
issue.
on that, and then depending on that submission, either calendar the vested rights application for a couple months from now.
Right.
Or allow everything to remain off calendar.
I think we should wait for everything to remain off calendar, because if it wasn't a valid permit, then what is, so that if this is all hinging on whether there's a valid permit.
I mean, I think DOB has recognized, they have recognized that it's a valid permit that has curable errors.
Right.
Okay, is that
So-
the case? Okay.
Yes.
The errors are being cured, but not as.
But they're curable, so.
They are curable, and we're in the process of curing them.
Right.
Okay, so,
Right.
oh, I see. So we could actually, if DOB were willing to send us a letter, which they haven't done yet, right, that says the permit was validly issued and we're working through the curable errors currently, then we could, if necessary, move forward with the vested rights?
That's
Is that what you're
exactly
saying? Oh, okay.
But it sounds like they have some work to do, so taking it off calendar isn't a problem for anyone, any of the members of the board.
Right.
Yeah, just for clarification, the objection itself has been resolved through the ZRD1 determination. What that determination said was also that it's conditioned upon us coming back to DOB with a layout that shows partitions and furniture so that it actually looks and feels like a medical office. And that is something that we're doing now, and we have a meeting scheduled with the Borough Commissioner for April 15th to review those plans. So that will, but the objection itself, which deals with courts, is no longer outstanding because it's not a court. So that's been resolved. The detail is to show that what remains in the rear yard is truly a medical office. And that's where those plans will be reviewed on April 15th by the Borough Commissioner.
But you gave us a letter saying that no construction work was going to be involved.
No, I said minor construction work is what I said, I
think you
believe.
said no construction work, but you
Well,
still
I mean-
have to remove the mezzanines and modify the egress, and that will involve.
No, what we have to do, what remains to be done is once the Borough Commissioner approves the modified partition work, it's a matter of erecting partitions and removing a mezzanine. That's all that remains.
And removing the mezzanine.
Yeah.
Oh,
It's not minor.
right.
It's pretty big
It's all-
structural work.
it's relative,
Big old
okay.
mezzanine, you
And you
got
have
there.
residents.
Yeah, you have people occupying,
What's the status of that?
yeah.
I haven't been able to speak to the client since the exec session to verify, but I know that as far as I understand, it's not occupied, the rear building is not occupied for residences right now.
Sounds like
That-
DOB council.
DOB
has a different-
doesn't seem to agree with that.
I don't agree.
Well, I'll discuss it with him afterward.
Okay, maybe they went to a
But the-
different
the-
room than you're thinking about?
Irrespective, we're not going to get to where we want to be unless DOB is comfortable with the rearrangement of space, so it can't be occupied for residential.
But, you know, in terms of how you've noticed how the board operates, when you have a violation, we don't grant an approval till you clear stuff up and you have a clean site, right? So actually taking this off the calendar till you have a clean site means that we could easily move ahead on the vested rights application and do it quickly, knowing that you've taken care of everything that you need to take care of, and then we could handle it quickly if it turns out you actually need that. Right? As opposed to working on it now, where basically we're saying, come back when you've cleared up all the violations.
I agree. And the alternative, if you did lapse and you don't fix all these problems that DOB has identified, then we could move forward on the CO revocation.
That's correct. That's
The
correct.
CO was issued in error.
But that's the point, is that we mark these cases off the calendar, we move forward on resolving our issues to DOB satisfaction, at which case they say, okay, we're clean. Now both the C of O revocations was drawn by DOB and our vested rights application is drawn by us.
It's only withdrawn if you don't need it.
Yeah, exactly. Yeah, understood.
Okay.
Okay.
Great, thank you.
Just, if I may have one, again, and this may be a question of semantics, but as far as the department is concerned, the objection is not removed
Right.
until the auditor reviews it and removes it on their sheet.
Okay.
All right? And there are additional objections concerning the building code as well, which would have to be satisfied for the audit. So there's perhaps more than, I think we can all agree there is work to be done on this.
Okay.
Thank you all.
Okay, thank you very much. Thanks for coming. Okay. So do we have to vote to do anything or no? Okay. Okay.
Give me 1 second, let me just write this down. Okay, new cases, item number 10, 315 14A, 485 7th Avenue, Manhattan.
Hi.
Hi, good morning. Good morning, Chair. Good morning, Commissioners. Commissioners. My name's Jody Stein with Herrick Feinstein. We represent the applicant for this MDL waiver application at 485 7th Avenue. I attended your executive session yesterday and would like to respond to your comments and questions. If you don't mind, I'm just going to mix it up a bit to get some of the easier ones out of the way. So first, with regard to the light and air easement, thank you for pointing that out. Very much appreciated. So we're happy to file a restrictive declaration since the owner is the same for the air parcel and the owner of 485 7th Avenue, and include the same limitations that are required by the DOB's form of light and air easement, and hopefully that will be satisfactory. With regard,
I mean, just to point out, it's not about satisfactory to me. It's just that either you're getting an easement or you're not getting an easement, and you're not getting an easement if you do it like that.
I appreciate it, and yes, thank you. So with regards to the preservation of the sub-area and the special Garment Center District, the chair is correct, we did drop a footnote with regard to this point, but basically the zoning lot is within the preservation area sub-district of the Special Garment Center District. It's less than 50% in the preservation area, and it's also located on a wide street. So any limitations for that preservation area don't apply to this zoning lot. We will revise the statement of facts to include it in the body of the text so that it's apparent to everyone. We weren't trying to hide it. We just thought a footnote was good, but happy to provide it in the body. With regard to MDL lighting and ventilation, so the applicant will of course comply with the requirements of the MDL and code, and we're happy to include that as well in the statement of facts, if that's satisfactory. So getting to the LPC. So we're at the LPC for a certificate of appropriateness. As you know, this building was landmarked with the cooperation and support of the new owner, which is the applicant. And so that was done in October of this past year. And it was because of the prominent historic hotel status, which is located by Penn Station, and its use of the light wells and courts from the original architect, which actually housed 1,885 hotel rooms at the time, which is significant. And the hotel was operated from 1907 through the early 1980s, when, as you know, it was converted to commercial office use. So the applicant had one public hearing in mid-March, and we're happy to report they received unanimous approval. So we're very happy about that. They also received unanimous approval at the community board hearing. And they are right now working through some minor details which are going through staff level at the moment. So the plans that were approved by the LPC are slightly different from the plans that were submitted as our revised proposed plans to the board. Changes include the removal of some hotel rooms from the 2nd and 17th floors, making the 17th floor solely amenity space, a slight change to the height of the mechanical bulkhead on top of the 17th floor. And we will provide the board with the revised set of plans that reflect the LPC approval.
So that has an effect on the whole shadow study and everything, right?
So the shadow study...
Touched it. You can't touch these.
The shadow study will be updated if it needs to be, but I have a feeling, and Ian can speak a little bit more to this, that the shadow study that was conducted actually took into account the height of the approved LPC building, but he'll speak more to that.
Okay. But if I understand correctly, it's only rooms that are hugging around the east court. The amenity space is on the west court.
So now there's no rooms on the 17th floor, so it's all amenity space now.
But if you just remove the rooms, unless you replaced it with amenity space, then there's no longer an issue
We
about...
replaced it with amenity space.
Right, okay.
So it's the same bulk, although it was
It's the same bulk.
brought in tighter a little bit, as you can imagine from the LPC. But we will provide you with an updated, if we have to, we'll also provide you with an updated shadow study to reflect the conditions in the LPC approved plans.
You don't have a copy of the 17th floor as approved by LPC, so we can know what we're talking about?
Yeah, so. So.
You take the mic with you, Jody? You're going to talk with us?
Sure. So this is the 17th floor, the outline.
Uh-huh.
And instead of the rooms, that there were 5 rooms proposed, it's just going to be amenity space with the same lot coverage.
The same.
The footprint is the
So it still
same.
wraps the eastern court.
It does still wrap the eastern court.
So is there a reduction in the number of rooms overall?
There's a slight reduction in the number of rooms overall. That's correct. So there was a comment with regard to the east inner court, which I think was the most substantive comment. So our argument actually remains the same, and I'll refer to the plan in a moment. But we'll revise our statement of facts and findings to make it implicitly clear that we're not going to be fully restoring the historic. Thank you. Explicitly clear that we're not going to be restoring the historic east inner court 100%. So we're actually, and I'm going to just go over here. So on the south side of the court, we are going to be coming within 4 feet of the historic dimension. Bless you. So the north to south dimension of the east inner court used to be 42 feet. That was the historic dimension. It will now be approximately 38 feet. Now the east-west direction it will be restored, and it is still 26 feet. So it won't be the compliant 30 feet that it needs to be, and the north-south direction is the compliant 30 feet. It's in fact 38 feet. And so the actual, regardless if we restored it 100% or the way that we're restoring it today, it would not be a compliant court because of that 26 foot east-west dimension.
But the reason for not bringing it to the 4 feet is?
So the reason for not bringing it to the 4 feet is because they need a hallway and rooms to front on that West 36th Street frontage, which provides great light and air, by the way. And they wouldn't have compliant rooms or efficient rooms or feasible rooms if they were to bring it all the way. So they really wouldn't even be able to get MDL compliant, which I think is 60 square feet rooms in there with at least 6 feet in one dimension. And then the argument from the engineer, which talks about making the east court compliant, would still remain true because it's that 26 east-west dimension they'd have to bring to 30 feet to comply with the MDL, and that would structurally compromise the building.
Oh, it's not the north-south?
It's not the north to south.
Okay.
So we will make it clear.
If you could have the engineer clarify that. It
Sure.
sounds like the relocation of any of the walls of the court compromise the structure.
Well, it's really the structural columns because that's what it would be. You'd be taking out the structural columns on the east-west dimension, which would compromise the structural integrity of the building.
So that's what's not clear. It just
Okay.
sounds like any adjustment to the court size would compromise.
We
So
will make that.
basically, though, in the 80s, the court was reduced to this level, is that correct? To this point of 30 whatever feet? The 4 feet were removed, or that's what you're proposing to do?
We're proposing, so it was, the court was infilled to a greater degree, and varying degrees depending on what floor you look at. But we're proposing to move it back to 4 feet from its historic original dimension.
Right. Okay.
And then I'm actually going to turn it over to Ian from Urban Cartographics for the shadow study.
Good morning, Ian Rasmussen, Urban Cartographics, on behalf of the applicant. I heard your comments at the review session. I could address some of them right off the bat, and then I'll go into just a little bit of a summary of the study and the work that we did and what we looked at. At the outset, I believe on the first page of the shadow study, you noted an error as regards the height of the building on the site. That was the height that appeared on the certificate of occupancy. I believe that table was put together before we had even received plans. So we will submit a correction to that. And then I'm going to pass this around because I understand that there was at least some discussion of surrounding buildings. That was not the emphasis of the original study. So to put everything in context, we're looking at an enlargement to an existing building, which is, I think, relative to the size of the entire building, can be said to be small. And we're looking at that enlargement as far as its shadows are concerned in the context of Midtown Manhattan. So I think it goes without saying that a good amount of the shadows that are cast on this building, on these courts, and even on the surrounding buildings are shadows that are cast by other existing buildings in the neighborhood. And you'll note in our study that there were certain timeframes in which there's a minimal impact, or certain timeframes in which we didn't analyze a new impact at all, owing to the height of the surrounding buildings, such as 1 Penn Plaza, and then if it ever happens, maybe 15 Penn Plaza, if that is ever developed at the Hotel Pennsylvania site. What I wanted to introduce with the boards was some of these additional services that would in theory be shadowed. We haven't performed the same level of detailed analysis against those walls because it's a more recent issue. But as you can see, these appear to be ventilation shafts.
Ian, take the mic.
Sure. As best we can tell, and these photographs were taken when we originally visited the site with an eye towards the courts. I found these images left over. So this is the nature of the walls that would potentially be shadowed by the enlargement. Of course, the enlargement doesn't cast a shadow upwards, and indeed.
Wait a minute, sorry, they would be shadowed by the walls of the enlargement?
What I mean to say is, so the enlargement would sit right here.
Right, wouldn't those things be removed or incorporated into?
No, I'm referring to this wall of the next building. So if there is any concern on the board's part about those neighboring buildings, I think you could see if this is not a sunlight sensitive wall.
No, it was more that the shadow study that you had that talked about surrounding buildings revealed that you were working with 180 feet as the height, which isn't the height. So then your shadows would, I think that was 180 feet. So then your shadow study would have been off because it's using the wrong.
I'll confirm. I know that midway through, the applicant did provide a revised set of plans, and the original model was edited. There were a few more points where maybe some clarification is in order, or maybe some reformatting of the study. I think the main thing that was sort of lost, and perhaps it wasn't clear enough in our writing, is that some of the dimensions that were provided for shadows, those spoke to the peak moment in a given day in which a shadow occurs. And those dimensions appeared alongside a duration in which a new shadow would be cast. So for instance, if it said that a 20-foot shadow would be cast and a new shadow was cast over the course of 10 hours, I can see how that might be misunderstood as meaning a 20-foot shadow for 10 hours. But what we're saying is that there's a shadow and it begins with nothing, and then a incremental or marginal shadow is created as a result of the proposed enlargement, which peaks in size and then shrinks again. And then it's not always perfectly symmetrical given the location of the other objects, the intervening objects that affect the way the sunlight hits the building. But the dimensions and the images you were shown were the singular moment throughout the analysis day where the greatest impact was had. Indeed, with the exception of that moment, the rest of the analysis period has less of a shadow. And at the beginning of the impact period, the shadow is inches large as opposed to feet.
Well, but if it's over a 13-hour period, there's a lot of hours where it's not inches.
That's true.
To get to 87 feet, there was one that's like a huge shadow. So in order to progress, and if you really want to tell your story, and you see you've got such a long duration, I mean, if it was a 2-hour duration, right?
Yep.
But it's 13 hours, it's the entirety of the day.
Mhm.
So if you really want to tell your story, then you indicate, every hour it reduces by X. So that, or you show that the shadow actually isn't having an effect on the windows that are in question somehow.
I understand, and there was another comment you mentioned about showing just where the floor lines of the building and the location of the windows in question.
And the dimensions of the shadow, because when
Sure.
you say it's 24 by 87, that's a bit gigantic rectangle, a 9-story rectangle.
Got it.
But in fact, it's shaped like, a bat or something like that, so it's a totally
No, indeed, most of
different-
them appear, I think you said yesterday, as wings or flecks.
Right.
And of course, our focus, and you see it's shaded in red in the study, is the incremental difference. So in fact, I mean, one could say that these courts for long parts of the day and long parts of the year don't get a lot of natural sunlight as it is. And, we, in large part, would not be changing that fact.
But you're talking about an incremental shadow, that's
true.
showing the change.
Yes.
So it's true, if it's shadowing itself, then it's not an incremental shadow, so that's either your study's wrong or, you should be focusing on the incremental shadow. That's
No, I only mean that thin sliver of incremental shadow that might be seen at any given time frame, it stands in the context of a much larger shadow that's already cast by the building itself.
Well, then it's not incremental.
Well, no, the areas shaded in red in the study, which are that sliver, that's the difference that's attributable to the proposed enlargement.
Right, understood, but that's what you measured,
Yes,
according to your chart.
right.
So the incremental shadow in some cases was very large, according to your chart.
At least for a moment in time, yeah.
At least for a 13-hour duration, which gets longer, and then gets shorter, and then there's a period where it's pretty long, right? As it's getting long, it's an inch.
Yeah.
But over the course of the day, into the 6-hour period, there's a point where maybe for 3 hours of it, it's pretty long. 3 hours on the other side, it's pretty long. And if that's not the case,
Right.
how do you show us? Because you haven't shown us.
No, the only point, the only sort of modification to that statement I would make is that the numbers you were given are the absolute maximum
Understood.
impact. So it's not that the shadow is X feet for a period of an hour during the midday. That's literally the moment at which it maxes
Understood,
out.
but it's also doesn't just appear. It doesn't go 1 inch to 87 feet.
That's true, and we're more than happy to show you either a series of images or maybe a sampling of times, and we can revise this
Because
accordingly.
again, you're communicating visually, but make sure you communicate. Otherwise, it's just a bunch of pictures,
Okay.
right?
The last point I wanted to make, as long as I'm here, and this is one that was sort of a lot of discussion for the project team, is that as a result of some of the modifications, particularly to the eastern inner court, there are areas here that are being opened up. And what we haven't done, because it becomes a highly theoretical exercise, is to show you the extent to which new sunlight is entering that isn't there today. And
I don't think that's necessary.
Okay,
Because it goes
but
without saying that if that infill weren't removed, I don't think we'd be having a discussion here. Everybody would be saying,
Right.
take out the infill.
So,
there's
but-
no reason to,
I'm only mentioning it because we're talking about new shadows that stand alongside new sunlight.
sort of, yeah, okay.
Any
If
questions?
anything,
Yeah.
frankly, they're reducing the size of the historical court. So if anything, they need to make a case for reducing the size of the historical court, which I think, the floor plans show that you can't get a corridor in there, but rather than even going into the infill, right? So just skip that.
Okay.
Okay. Any other questions for you?
Thank you. And it's also, I think, worth noting that some of the mitigation is to provide a glass curtain wall so that the windows that exist today, which are very small because there were 1,885 rooms, will be made larger so that they can get the maximum amount of light reflectivity and sunlight into those rooms.
With respect to that, I don't think that, I think it was important to say that it's going to be a glass enclosure, but there was no kind of written comparison of what the standard window is there, and so, it was a 3x5 window, and that only gave you 15 square feet, and now you have a full curtain wall, and it's going to give you
We'll
2
include
X
that.
square feet, right?
That's, yeah, we'll include that in our revisions. So we will be revising the statement of facts and findings and the shadow study to reflect the most recent, the LPC-approved plans and the comments heard here today. And so we would like to ask, unless there's anything further,
Yeah, there are.
If you are revising the plans, could you put where you're locating your ambient lighting on those
Sure.
plans so that you could see it?
In the courtyard?
Yeah.
Yeah.
Anyone else have a question? Okay, you're okay with the loss, serious loss analysis?
Yes.
Yeah, okay. So before we do that, we just need to see, are there any speakers on this? Okay. So what would you like to ask for?
I would like to ask if you could close the hearing and leave the record open for our revised statement of facts and shadow study, so that.
How
we can
about
move-
this?
Yeah.
We could do a closed grant if you submit everything and it's wonderful.
Sounds perfect.
Because when we've done it the other way, sometimes we have to reopen, and that's too bad, right?
Okay.
Okay, so how much time do you need to make your submissions?
2 weeks.
2 weeks. So if you could submit, see, that says 1, 2. So that means you could submit on the 16th of April, does that sound right?
That sounds right to me.
So the 16th, but not or the 14th.
We can do either.
The 14th would be better.
Okay.
Or even the 13th would be better than that. So, because it's not Thursday, and I want to give you enough time to actually do the work.
We'll work weekends, it's fine.
Okay. Do you hear that, Ian? Okay, so submit Monday the 13th.
Okay.
For the hearing on the 28th of April.
That's a possible.
Sorry?
That's a possible.
That's a possible closed grant, assuming everybody does an excellent job and answers all the questions.
And it will be done.
So
Thank you.
416 and 428.
413.
Sorry,
413.
413, sorry.
Thank
To
you.
give us enough time to load that onto the system and all that.
Thank you
Okay.
very much.
Thank you.
Item number 11, 1615, they worked, huh? 1615A, 233 Water Street, Manhattan.
Richard Lobel of Sheldon Lobel PC for the applicant.
Okay, are we done?
I think so.
Cool.
The Madam Chair, the applicant had originally approached the Department of Buildings and attempted to receive a determination that due to the historic status of the structure, that the reference flood regulations were inapplicable. That was rejected at the time. We proceeded at the BSA, and now it's been the determination, I understand, through council, as well as Department of Buildings, the Borough Commissioner for Manhattan, that indeed we were correct, and that the cited regulations do not apply. So I guess we've received email confirmation of that, but maybe if the board wanted to leave the matter open for
So you
2
have
weeks,
part- Yeah, that's fine. Yeah.
such that we can confirm that the Department of Buildings will not reverse that determination and proceed from there. So this
Great, okay.
shortest possible adjournment, and hopefully we can take this off.
Next time you have a problem like that, call us.
Done. We tried really to make it the first go-around, but
Okay, appreciate it. So do we have to do anything to just keep it open and for 2 weeks, and then you'll let us know and
great.
submit a formal withdrawal, assuming
okay,
everything's fine?
fantastic.
Okay, great, thank you.
Thank you.
What's the date?
So you can put it on for the 14th?
14th?
Yeah, okay.
Continued hearing, okay.
Yeah.
Zoning calendar, decision items, item number 12, 254 13BZ, 2881 Nostrand Avenue, Brooklyn.
Morning, Madam Chair, Commissioners, Marvin Mitzman, the applicant.
Okay, for a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you very much.
Thank you.
Oh, shoot, wrong
What?
place. No, sorry,
See, now we know what happened.
sorry.
Edit the film.
I put the vote in the wrong place, sorry. Item number 13, 4614BZ, 25260 Atlantic Avenue, Brooklyn.
Good morning, Todd Dale for the applicant.
And we do have DOI sign off. So for a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Item number 14, 5614BZ, 161-51 Bailey Boulevard, Queens.
Good morning, John Ronan, appearing for the applicant.
Okay, so this would be a motion to grant on a short term for 5 years. I know this is a new owner, but it's such a problematic site next door. We need to make sure that it's being well maintained. So for a motion to grant on condition, or on a short term, really.
So motion to grant.
Grant on a
Is it-
short
Chair-
version.
May I clarify? Is the short term is 5 years?
5 years.
Thank you.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Item number 15, 6314BZ, 5500 Broadway, the Bronx.
Good morning, Todd Dale for the applicant.
Okay, we also have DOI sign off on this, so for a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Thank you.
Thank you.
Item number 16, 12414BZ, 11112 Gilmore Court, Brooklyn.
Richard LaBelle, Sheldon LaBelle, PC for the applicant. Madam Chair, we discussed the comments at the executive session with the applicant. It was their hope that actually they could receive some further guidance from Department of Buildings, such that while we understand that as a zoning matter, it's possible to receive a grant of this case, we would rather resolve any issues before rather than after, and which would prevent us from having to come back to the board potentially for a letter of substantial compliance. If the board would acquiesce, we would ask for an adjournment until, I believe, the second week of May, if there's a hearing that date. At that time, we would have sufficient time to, first, we're going to update the survey to make sure that we have the most accurate data, and then to approach the Department of Buildings and attempt to receive a final word on the placement of the mechanicals in the cellar.
Okay. Terrific. Okay.
Did you want to reopen this?
Yeah, so we need to
Sure.
reopen. Okay, so for a motion to open?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Okay, so then you'll make a submission, you think you have enough time to make a submission like on the, what is that? Sorry, on the 23rd of April? Is that enough time?
We were hopeful for 1 week later.
Okay, so the 30th of April, which gets you to the hearing on the 19th.
Is there a possibility of?
Oh, it could be shorter because the only thing that's open is this question.
Correct.
So yeah, it could be the 12th. Okay. So submission on the 30th of April for a hearing on the 12th.
Right, and hopefully if we could potentially, to the extent that the issues are resolved, do a closing grant on that date. Thank you, Madam
So it's the
Chair.
actual use of the cellar, the utilities?
Correct.
And also the building height, I believe, is measured from grade and not from the design flood
Correct.
elevation?
So we'll make any of the adjustments that are necessary.
Okay.
Thank you, Madam
That's
Chair.
great, thanks.
Item number 17, 14314BZ, 746 61st Street, Brooklyn.
Good morning, Todd Dale on behalf of the Office of Fair Plot.
Okay, sorry, still typing. Okay, so it's on the, okay, so for motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Continued hearing items, item number 18, 350-12BZ, 532nd Street, Brooklyn. Richard LaBelle of Sheldon LaBelle PC for the applicant.
Madam Chair, I know that there had been some confusion over the submission, which we understand was made timely to the board, but there was questions as to whether or not the board had adequate time to review. We're okay?
We didn't have adequate.
Oh, we did
time to
not.
review, Right.
Okay.
I think we got it on.
We didn't see it. I didn't see it.
Yeah,
Okay.
we got it on Friday. It's not possible.
Okay,
Right.
we actually did make the submission prior to that time. I think that Mr. Saul indicated that there had been some questions as far as getting the file to the chair. So, so it was our understanding that we would discuss it at this hearing. If not, and the board has not had a chance to review, of course, I'm sure we would continue.
Well, I think one of the other comments that Commissioner Otley Brown had that I thirded and seconded was that it's been so long since this application's been heard. In fact, of course, I've never heard it.
Correct.
You know, last time was in August, that it's appropriate, instead of requiring everyone to go back through their materials, and I noticed that in the stack of materials, there's a lot of submissions that are not the kind of thing that are substantive to this case, right? So you have to weed through all that stuff to find the substance. It would be a lot better if you summarized where we are.
Great.
What's been established, what the open issues were, what you're curing by this submission, and then we could move forward with the analysis. That would be the way to help us.
We're happy to do that. I think that, to Madam Chair's point, the last substantive discussion of this matter was in August 2014. After that time, we were requested by the commissioners to explore the issue of federal preemption, which we did rather thoroughly. Went to the Department of Buildings to not receive a final determination, but to receive their opinion. They did not concur with that. So while we reserved the right to make that legal argument in the future, the decision was made to proceed on more typical variance findings. We think it is well served to provide the board with a summary of where we stand, our understanding about the satisfaction of the findings, and the current submission, which we will, in essence, resubmit, really dealt with the character questions that were raised by the board at that August hearing relating to the appropriateness of this site for homeless housing, as well as the, from environmental concerns, whether or not there was issues over truck traffic and other issues of a traffic and transportation nature. So while we feel that we have really good evidence to support that, I think it's, understanding that the board would prefer not to hear it today. We would ask for a quick turnaround, and we'd be happy to come back in and outline some of the pressing issues.
Okay, but a quick turnaround would include your submitting a summary to
Correct.
say where we are, so actually we don't have a full submission. Right? The other thing is, EDC submitted a letter in protest because this is in an IBZ.
Correct.
So you really should respond to how this affects the IBZ. They
Sure.
also stated that it's across the street from a recycling facility. How does that work with the safety of the occupants and air quality issues? I actually don't know whether that's been studied, because I haven't looked at the
Sure.
materials, but you should be looking at all that, and you should be going back to the EAS and making sure that it's covering all those kinds of areas. If it's doing a weak job, it should be beefed up,
Sure.
because no reason after all this time that it turns out the EAS isn't even addressing the areas of environmental concern.
Of course.
Right. Okay. So you're not, let's just say you're not ready.
We will be.
Okay. Any other comments for this? Are there any speakers on this item? Okay, so what do we think?
So I think while there is a lot of material, much of it has already been diligenced, so we'd say 2 to 3 weeks.
Okay, so then, I guess that looks like, again, a submission on the 30th of April for a hearing on the 19th of May.
I guess, Madam Chair, the applicant is in discussions with the federal government, which was the Department of Health and Human Services was originally the grantor. So I'd only ask, I think we would be in May anyway, but if there is anything earlier in May, we might be better served.
There's May 12th, but then you have to submit on the 23rd. The 23rd. so I don't know if that's enough time.
You think what? That's
I
not
don't know if that's
insufficient?
enough time.
Okay, so I guess for the week, we might as well just go to the 19th.
Yeah, okay.
Thank
So
you.
the 19th with a submission on the 30th of April.
Great, thank you.
It's different than the other one because there's a lot of materials to
Oh,
go
sure.
over.
Understood. Thank you, Madam Chair.
Item number 19, 225-13BZ, 810 Kent Avenue, Brooklyn.
This one is being withdrawn.
Item number 20, 264-13BZ, 257 West 17th Street, Manhattan.
Good morning, Frank Angelino on behalf of the application. Like to have David Koch of Criterion Acoustics go over both the ceiling work and the floor work so that it's described in verbal detail, and then we could follow that up with actual drawings of the floor. Second, after that, Jeffrey Kaplan, who is the litigation attorney for the gym, will bring you up to date on the status of the litigation, and then afterwards, Jared Paramoto will talk about moving forward. And then I'll come back, and then we'll hear from anyone else who wants to speak, if the board agrees to that. Thank you. David Koch. David Koch is the head of Criterion Acoustics, who is the acoustical consultant for the Brick Gym.
Hi. I just wanted to go over...
Can you state your name, please?
Oh, David Koch, Criterion Acoustics. I just wanted to go over 3 points that have been raised recently. The first being the ceiling that we recently installed. There was an Acoustalog report that was recently issued with some issues with the ceiling construction. We had the same comments. They were issued repeatedly in punch lists. I was there yesterday. They are performing the final caulking, and we should have final sign-off from the contractors by end of day today.
So you have photographs to show that all of those kinds of things were corrected?
Yeah, we'll send a formal field report.
Including all the springs that were engaged rigidly?
Well, I want to touch base on the rigid springs. The manufacturer, so going through the spring selection process, we specify the ceiling, 3 layers, 2 layers of gypsum board, 1 layer of plywood, and we send it to Mason Industries or Kinetics, and they specify the loads on the springs. They produce shop drawings through their licensed engineering staff, and they send them in for submittal. They performed all the load calculations, and recently were out there saying the springs are in fact performing correctly.
And installed correctly?
And installed correctly. So I can get a letter of release from the manufacturer, if that.
Okay, yeah.
Okay. So that addresses those 2 points.
And you replace the access panel?
Yes, they're all covered with 3 layers of sheetrock now. Anything else to address on the ceiling?
I don't think so. Anyone else? No.
Okay. There was discussion on the limiter that was installed on the sound system, and there was discussions of whether it was working properly. I guess I disagree with Mr. Firestein on it, and he disagrees with me, and I think that's just an opinion of 2 engineers disagreeing. We discussed bringing a third party in, and the third party, I think, will resolve that. I don't think I have anything further to say on that. The third item to discuss is where we stand with the floor system. I think, you've seen my reports for other CrossFits, and we've worked on a fair amount of them. And we have a platform design we've used at other CrossFits in New York City with great success for vibration isolation. We built a mock-up and tested vibration levels on the structural slab, the ground floor structural slab, and we believe this is going to be the solution. So when the third party is engaged, they can perform testing, give us the go-ahead, and we will construct it.
But there's already cutting going on, I don't understand. So why would you do those cutouts in front of the lifting stands if it's not been a tested result?
Well, we know the mason slab's failing for the use of the gym.
Right, but you're
I mean,
only
there's
cutting
no-
out rectangles in front of
Right.
each rack.
And that's commonly used in many CrossFits where the weightlifters only drop in those locations. I mean, you physically, if you're lifting, the weights are going to impact there, immediately adjacent to the lifting racks.
Don't you have a problem with your slab not properly floating?
What,
Existing slab doesn't float properly, right? That was established a long time ago.
well, it floats properly. It's not designed for this type of usage.
I thought it's engaged with columns, it's only 1 inch off the ground, which means it's probably no inches off the ground because concrete drips and,
Right.
so then anything with your installed, I mean, you're cutting those little mats so perfectly in front of the lifting stands or the rack. So like there's no margin for error there. And it seems to me that, without even getting into the structure, which Commissioner Montanez will get into, your pad will move, and
Well-
it'll hit this totally engaged floor slab.
The pad has an inch clear around it. We may even go to 1.5 inch clear around it. It's in a steel frame, and it's attached with an air spring, it's attached from this lifting platform to the structural slab below. So they're seismically restrained, essentially, laterally
So there's going to be
restrained.
columns going down to the cellar floor?
No, it's air springs that are going to be local, like 4 per localized lifting platform. It's then a layer of plywood, 2 layers of Durock, a layer of plywood, and then 4 layers of 1-inch open cell sponge rubber with a final topping layer. So it's a pretty massive system.
To the first floor, so it'll?
Yes.
On the first floor, so?
Correct. We are also putting lifting platforms in the basement.
So can you submit, we never received details. I think we received photographs, but no detail. Like when you did the ceiling.
Yep.
You submitted to us details. We had comments about
Sure,
the
yeah.
details, and you modified
Mhm.
accordingly.
Yep.
So can you please submit us
Absolutely.
details and test results on the use of that? I'm assuming
Yeah.
there's testing lab reports?
Well, we've tested it with drops on the structural slab with an accelerometer to gain the vibration levels. We have not been up in the second floor apartments to perform testing on this system.
Aren't there like ASTM testing results?
No.
Some testing, there's no testing lab involved in this?
No.
This is your invention, is that? Okay, so you invented this kind of thing on springs?
Yes.
Okay, so, but don't you have test results from other installations?
Yes, absolutely.
So can you give us those?
This system's even further enhanced. Normally, we use a rubber isolator with a fair amount of air gap, and this one, we're using air springs. Most CrossFit gyms cannot afford air springs. They're inhibitively expensive to do, but this is a different situation.
So you actually don't have any testing?
Well, I tested it this week,
But you
did the
test-
or
mock-up.
last week.
You tested the mock?
Correct.
Okay, so maybe you could. send us
Absolutely, I can
those.
submit the
Sure.
vibration levels on the structural slab and the structural column.
Could you also provide a plan, a location plan of
Yes.
where this is?
We will
I'm
put a
sorry.
formal drawing set together of what we believe is the best detail, submit our vibration data with that, and then Frank and Mr. Angelino and Mr. Kaplan can further discuss the next steps with the third party and how we want to proceed. Does that seem reasonable? Okay.
But when you I'm just curious, when you tested it, what did you do?
We had
Test?
essentially an accelerometer, a vibration sensor, on the structural slab, about a foot away from the platform, to see the vibration induced to the strip base building,
By dropping what?
135 pounds from overhead.
From one of those kind of drops?
Yep.
Okay.
The tests yesterday were very positive. The vibration levels were very low.
And why do you test with 135 when we hear that 185 gets dropped?
That's what we could get up yesterday, getting up 100. You have to have lifters to put 185 pounds up.
So, but that's what's curious about this. People keep going on and on and on, like ad nauseum, because we've been here a lot of times, right? About dropping 185 pounds, right? And unless no one can lift 185 pounds, which isn't the case because we watched it in video, then unless no one is dropping 185 pounds from up there, which also sounds surprising once they all know that there's going to be these pads, I'm curious why we're not seeing tests with 185.
What I'm going to, could I have JP speak to that? Because I'm not in charge of gym operations or oversee who lifts what in a gym daily. But I can provide, the data and the drawings as requested for comment and review. Is there anything else from me?
I think that's it. Thank
Okay,
you.
thanks, guys. Good morning, Jarrett Promoter. Just to quickly address, because I believe I'll be coming back up. So first thing is on the room for error on the drop platforms. The way that they've been designed at anywhere between 3 and 4 feet wide, maybe in the pictures and diagrams it doesn't show this, there's quite a large area built for error and a margin. So it shouldn't be an issue. Like directly, it will not be an issue.
How wide is a
A weight plate is only like 3 inches wide.
No, but the entire bar plus the plates,
Plus the plates, you're looking at about 60 inches in total.
60 inches is
But you
5
have to understand there's an extension off the collar where the weights are held.
Right.
That has about 5 or 6 inches of error as well, that doesn't actually have weight plates on it. So you have, if a weight plate drops, you could have anywhere from 2 feet on the left of the weight plate, anywhere from a foot to 2 foot, and 1 to 2 feet on the right side, which is a huge area. Huge
So what's
area.
the dimension from center line to center line of the weight plate?
From center line and center line to the weight plate, it depends on the
Because that's
barbell
where
you're
gonna
using.
drop, right? It's gonna
Yes,
drop
but
on the weight plate. So what's your?
the center that you're standing on is 41 inches. So you have about 8 inches off of the end of your platform that you're standing on.
No. What's, okay, do the math. So.
I don't have the exact, I've never been asked that
weight
question, so I don't
plate,
have that exact math.
The dimension, I'm sure that there's probably, some give or whatever, but is it, in the center, right? I'm holding this.
Yes, ma'am.
What do I got? 3 feet, 4 feet between weight plate to weight plate?
Between weight plate to
4
weight plate?
5, depending on how
Yes.
big the person is?
No, the
And
weight,
so how then-
the
how-
space between weight plate to weight plate is fixed.
Okay, so what
Yeah,
is that?
from the
What's that
first plate is
dimension?
fixed.
From the first plate is fixed.
First, because you
It's,
put the big plate on first.
right, I have to get you the exact measurement, but it's probably around 50 inches. And I can pull it up by the time I get up here
And so
next.
your platform then
Is
is?
4 feet.
Is
It's
over
42 inches. That gives us all that room of soft drop area for error.
Wait
You
a minute,
understand
so
what I'm
your
saying?
math isn't working, that's why we need diagrams.
I'm confused.
Right.
We need diagrams because what you said is that the bar is 60 inches long, which is 5 feet, but the platforms are 4 feet wide.
Yes, ma'am.
And I have actually seen, because everyone thinks they're the strongest person on earth, where they actually stack all the plates until there's just room for that little
Right.
clip, and that's like 1.5 inches, and it's really scary, and then sometimes the plates fall off.
Right, we don't do that.
You don't do that.
No, that's
Still.
powerlifting. We don't do that.
Okay.
Oh, yeah, that's not something that we operate in our facility. So, but what I do want to make clear is, the reason why we don't test beyond 135 is because when this issue started forever ago, we set a new protocol in place where that was no longer a weight that we were utilizing. That's why we are testing a maximal weight utilized on a day-to-day basis.
Okay.
And I understand the opposing party will deny that for days and days and days, and will oppose that for days and days and days, but that's just the standard protocol,
Okay.
so that's what's happening.
Okay, so if your consultant could prepare a drawing that shows the size of the bar with the plates and the size of the platform.
Yes, even better than that, if you'd like, I can take pictures of the actual barbell on the raceway so you can see the visual room for error, so that you understand that there has been no modification to the math and/or diagram.
Okay.
You will see
That's
it.
good, but give us the
Yes,
actual
ma'am.
diagram with
The
dimensions.
diagram.
You will have it all.
With dimensions
And I
too.
apologize, my math's not that great.
Okay. Okay, thank you. Okay. Is there someone else who's gonna?
The attorney.
Jeffrey Kaplan, who is the attorney for Brick.
Good morning, Jeffrey Kaplan, Schwartzvene Kaplan. I am the attorney who represents the applicant in the proceedings before the New York State Supreme Court. As the board may or may not know, Judge Kenny had issued an order, the most relevant portion of that being that my clients were not permitted to operate their gym without the physical culture permit. We informed the board of that the last time we were here. My office had made an application to the appellate division on an emergency basis to stay the enforcement of that order. That was granted, I believe, in early February. What was required then was a full briefing and submission on those issues, and that was undertaken and completed. And then as of Friday, I believe, or Thursday of last week, the appellate division ruled against the applicant with respect to the application for the emergency stay and vacated that emergency stay. It's my understanding that counsel for the opponent has filed a bond as required by the judge's order, and that will require my clients for the present time to cease operation of their gym pending the granting by the BSA of a physical culture permit. So that's where we are with the proceedings at this time. The court proceedings will continue. I believe Thursday of this week there's a further conference before the judge, and we'll address the situation with her at that time. My clients have asked for a slight consensual reprieve of the enforcement of that matter. I believe we've asked several times if we would be permitted to operate the facility until the close of business on Friday. At the present time, I believe that request has been denied, and that at present they're asking that we cease operations at the close of business on Wednesday. Certainly this poses a lot of issues in terms of the 27 full-time employees who are going to find themselves out of work, as well as hundreds of members who at one point relied on the gym for their physical fitness endeavors, and we will deal with that situation. But certainly that poses an extreme hardship. Again, we've asked for a slight reprieve until Friday at the close of business, and I hope that there's some understanding on their part as we move forward. Very significantly, as Mr. Koch indicated, and as the board had suggested in the past, due to the extremely conflicting nature of both of the experts who are involved in this matter and their opinions with respect to data and what is truly being heard, there was a recommendation that a third party be retained. This morning, we have finally agreed upon Cerami, which is a very well-known acoustical company here in the city, who will be that third-party neutral acoustic testing company. I will sit down with counsel, my counterpart, and we will come up with the aid of both of the engineers who are involved so far for both parties with a protocol for that testing, and everyone will have input in terms of what type of weights, what amount of weight will be utilized, and so on and so forth. We will also test every other alleged complaint with respect to music and the system that plays the music, as well as voices, shouting, instructors' voices. Anything that's been alleged in the past will be included in the third-party analysis by Cerami. Having decided on Cerami today, it's my hope that we'll be able to implement and retain them within the next few days and get things underway, as my client certainly has, at this point, readied the prototype of the floor for Cerami to come in and provide that data as soon as possible. That's basically where we are.
So just a question, given that there's another expert, I'd recommend that that criterions show its detail, or it show that sample pad testing or pad installation to Cerami before it goes ahead and installs
Absolutely.
dozens of them.
I think that we've already discussed this. I think it's imperative that we bring in Cerami immediately as the company that's going to be doing the neutral third-party testing, and provide them with detailed drawings and all of the information that they basically would request in order for them to do their job properly and provide the data. Certainly that we'll also share with you.
So I'm not sure this is really your domain, I think it's Mr. Angelino's, but it's, so we'd like to see, as soon as Cerami is engaged, we'd like to see Cerami's report on this proposed platform and their opinion on whether they think the details are correct or if they modify the details. Okay?
Sure. Absolutely. I'll communicate with Mr. Ginsburg directly with Cerami to indicate that that is all important information, and you'll be provided with everything. Okay. I'd also note that initially we had proposed a different company we decided to select a company that was out of the area just to avoid any potential conflicts. But it was actually Mr. Ginsburg's office that recommended Cerami, and we've decided to go with the expert that they chose, and it's on consent, so there's an agreement to that. I thought that that was significant to note also.
Okay, thank you.
Thank you.
Any other questions for? Okay. Yeah, I actually do have a question, another one from Mr. Perlmutter, but.
He's coming up.
Okay.
Chair Perlmutter?
Yeah. So my question is, are there such things as as CrossFit gyms that don't drop weights?
The simple answer to that is yes. Yes. So the difference is, what do you classify, and this is just a straight up to be transparent, how you classify dropping from where you classify it as a drop, and how much weight you're dropping, and is it intentional or not intentional?
Right, right. I mean, I know all gyms, there's always some bad actor who doesn't listen to the rules that are on the wall that says don't drop weights, but basically you're not allowed to drop a weight in most gyms, right?
Yes, ma'am.
And so maybe you make a mistake or it's too heavy and you can't help it. That's an occasional drop.
That's how we operate.
But I thought that you have a regular program of dropping.
No, we actually rid it of that. When the first court order came in place, we went into a no-drop policy with a no-drop protocol. It's established on every single wall within the gym. It's within our culture. That's when we went into the platforms, and the platforms weren't so that we could drop. The purpose of this raceway that we're building is not so that we can drop. It's so that we can operate normally without any of these other means of complaints that are coming. The confusion over time is that it's become so regular to complain and say that they're hearing thuds and booms from dropping without actually anyone being inside the space to define what happened to cause that noise. So the simplest thing for them to do when they complain is to just simply say we hear thuds and booms, which means there's dropping. But it could be one of 8,000 things causing noise. And again, I'm not denying that they're hearing noise. That's not what we're doing. We have been in those apartments at times when we're not even dropping and hearing and dropping by means of testing, and we hear noises. Neighbors walking, the school behind us, construction projects. We've had documented for the last 10 months photos and videos and constant building permits that are around us that are happening within yards of us of construction that are going on. But it's impossible because if a complaint comes in from them at 4:42 p.m., they could be submitting it at 4:42, but it could have happened at 3:57. And we're not asking them to be precise, but in the same, everybody has to understand that there are other things happening. And again, we're not saying they're not hearing noise. That's not what today is about.
Right.
Because we're going to argue one thing, as the opposition, they're going to constantly argue another in attempts to get us out. What we're trying to say is we are doing what is needed to provide a facility that operates not only in good faith, but under the means necessary to continue forward without noise issues. But what is taken as new issues, I don't know. Sorry if that was a long-winded answer to your...
Okay.
So, internally, we don't drop. As you mentioned, are there occasional? Yes, just like you may be in an apartment and hear an occasional pan or pot drop on the floor. It's not that, the tenant wouldn't immediately call downstairs and say, hey, I hear apartment 4C just dropped a pot. Let's kick them out. Or let's make them put in a floating floor because they walk around their apartment a lot. We hear these things. We instantly, out of respect, without anger, we let their side know, hey, we're sitting in the office today. There's nothing going on in the gym. We hear noise. It's possible you're hearing the same noise. We just want to let you know it's not us. And of course, days and days later, it'll come out without actually attaching the time we said, hey, we hear something. They'll have a complaint. We go, see, we let you know. We heard something too. So you're not crazy. It's just not us. And we don't know where it's coming from because we're concerned about what we're doing. So I did want to just clarify a few things. One is, you had mentioned, you asked why would we cut the floor if we knew that the floating floor isn't working. So what we did was we just repurposed the existing floor to act as the elevation platform to meet the level of the new inserts that we're putting in. So the current floor that's in there virtually is non-functional. We've anchored it, we've created a rigid structure out of it, because through our internal testings, we found that which was noted, the floating floor that we created and the structural slab were operating at a similar frequency, which was just exciting the levels and making it worse. So by creating a rigid structure, it pulls that out of the equation, okay? And I'm not an engineer, I just know what I hear and feel, and I just look at data. So that was the first thing. We've created that structure. We know this new system is going to work. We've done internal testing, we've done informal testing, is not to create an opposing party saying that didn't work because it was done at 2 o'clock and things only work at 3 o'clock. We just wanted to know that what we had hoped the entire time, and with the great financial investment we've put in, that we were in the right track. Because we got a lot of people telling us what is and isn't working, and we just want to make sure we're being guided in the right direction. We know that the people on our side are attempting to do that, so we've been focusing on that. We're very excited for what we have coming into play, okay? As you know, as Mr. Kaplan had mentioned, we've been operating at about 40% in the cellar level because, as you've seen by pictures, the entire upstairs is under construction. That main level floor in the center area is all under construction. You've seen the photos of where it's at. It's inoperable. So, as Mr. Kaplan mentioned, we did ask, out of good faith, that they provide us at least till close of Friday business so that we could properly inform our members and staff of what the rollout will be. Simply 2 days. That was the first thing. That was denied. And we're just asking again in front of you guys, if out of good faith and to show that we're just trying to work together to a resolve, as what we're trying to prevent is the idea that they just want us out and we just want to find a solution, because that becomes a very difficult argument to win. If one side, very, very strong, very powerful, financially very secure, who just wants a tenant out, they can do a lot of things to impose enough pressure long enough until you just basically tuck your tail and say, I think it's just better off we leave. But we believe wholeheartedly in what we're doing there and what we do for the community and the 27 employees and hundreds of people that live within our area, even the ones at times that lived in the building that were then asked not to be a part because of conflict of interest, that we do good for our community. We do know that. So I understand there's testing results that have to happen before you guys can do anything. But if I could ask, if there's any way even to grant a special conditions permit for 30 days that allows us through these final testings to operate as we have, which is just in the subcellar level with no dropping, no excessive weight use, the music as we know when we're down in that subcellar level, and of course they're going to come up here and oppose everything I'm saying. So we're already ready for that. I just want to kind of speak now or forever hold my peace.
Do you do any kind of quiet stuff?
If you
Pilates, yoga.
We do. I mean, the concern is we don't know where a lot of these issues are coming from. We've seen complaints at hours where we're not even open. And again, I'm not up here saying that they're not hearing anything.
Right.
You know, I live on an 11th floor on 7th on 7th and 24th Street. I hear everything. You know, I mean, I just do. I can hear the dogs barking. I hear the people on the street working till 5 o'clock in the morning, street workers, and they're an avenue over. So all we're asking is that to prevent any further irreparable harm, right, we hear noise.
Right, yeah.
That's not us.
Conversation.
That's not us. So we're just asking for a special conditions permit to save the well-being of the employees that we have in place and the current structure of what's happening, because we know we will resolve this challenge. We would hope that the opposing party would come up here and say, we hope and are thankful if that's what they want to do, as opposed to just saying, get them out. We want them out. Get them out. So that's what we're asking for. Special conditions, something that would give us a temporary ability to operate in the cellar level. Even if you guys want to impose further special conditions operational hours, things we can or can't do. We're willing to listen to anything. We've been doing that the whole time. We've always taken advice, the criticism necessary to develop a solution for this so that we can move forward beyond all the issues that were created that got us to where we are today.
Question for you. Can you provide us with a kind of, I don't think we've ever seen that, an operational plan that it describes the other kinds of things that you do in this gym? Because we don't really know what it is.
Absolutely. Yeah, I can provide it because we do basic boot camp style work that involves no barbells. We do yoga and stretching classes. We do leadership training amongst staff and members. We do a lot of things that don't have a bad reputation within the community in general, for certain. So even if it was a special conditions that limited us to programs that we could operate.
So we would need to discuss this with council, and also with, I think, Mr. Kaplan, because I think the judge is in greater control of your activities than we are, actually. So.
Right, yeah, because I know that the basic judge's order is that the condition is to not operate until we receive our special permit, our BSA.
Well, we should talk about it. I'm sure there's a nuisance claim too, so just don't know what that resolution is. Okay.
No problem. So pretty much, that was my speak now or forever hold my peace. Thank you for listening.
Thank you. Okay.
Nothing further at this.
Okay. I actually do have a question from Mr. Kaplan, I guess. So it's not like I reviewed the litigation papers or anything.
I can provide a copy for you.
Is there a nuisance claim here too? Is this only about that they're operating without a permit, or is this?
No, there's a nuisance claim also.
So then how does that even if?
Well, the effective part of the judge's order, which is really why we're here, involves the issuance of the physical culture special permit.
That's the reason you're here.
We're not ordered not to, there's no court order that says don't commit a nuisance or create a nuisance, because quite frankly, your idea of a nuisance is probably a lot different than Frank Angelino's idea of a nuisance.
The TRO is just pending this board's granting.
Well, I believe that I don't have a copy of the order in front of me, perhaps Mr. Ginsburg does, but the order, I believe, speaks to not dropping weights and not operating a gym without the physical culture special permit. I believe those were the two relevant factors. Right, right. It's my understanding.
Running outside, no breathing, and
right. There was an allegation that there was group running activity in front of the building, which was causing some disturbances to some of the residents. It's my understanding that is not an issue any further. It's not something we raised in the appeal issue either, because I'm told it's not an issue. I certainly haven't received a complaint about it in as long as I can remember. So if it's an issue, nobody's telling anybody about it.
All right, thank you.
Good morning. Good afternoon, actually, at this point. Jay Ginsburg of Lebanon Glasser for the condominium. A few things I'd like to point out about some of the things that we've heard. It's not like the condominium jumped up and said, we want you closed. This is 18 months in the making. Litigation was filed in October of 13. We moved for injunctive relief back then. We convinced the Supreme Court that the conditions were significant enough, the noise disturbing enough, that an injunction issued barring them from dropping weights, an injunction issued barring them from operating without a physical culture establishment permit, and further on the running issue. That has now been sustained or hasn't been stayed by the appellate division after considering voluminous papers that were submitted only weeks ago. We've heard allegations here today that they don't drop weight at all, but we've seen the videotapes and more than once, and wouldn't you know it, there's dozens of drops on every day that they show us videos for. And those drops strangely correspond with the complaints that we get. Now, do we complain about every drop that is on those videos? No. Are there complaints that don't correspond with every drop on the video? Yes. But are there dozens of instances where unit owner complained at a specific time, and wouldn't you know, somebody drops weight at that exact moment on the video, yes, in fact, that happens all the time. And it's not an accident that happens once a day or once a week. It happened in the 3 video day span that we had in January. I think we clocked 50 some odd times in 3 days. So this isn't exactly an oddity. The idea that it's only 135 pounds, if that's true, it's new. Because when we got videos months ago, when we were still in litigation, and we looked at them, they went up to 180 some odd pounds. We had some experts look at the videos, look at the weights, and tell us what they were. It's not that hard to discern.
See that on these are security videos.
Yeah, you
no?
can. You can tell how many plates there are, so. No, you can't see the numbers, but they're standard.
Standard, okay.
45, and then there's a 35, and there's a 25, and there's a 10.
Any gym rat can pretty much tell you what they are, but I went to actually trainers at the gym that I go to and who do CrossFit and asked them, hey, can you guys look at this video for me and call out the weight amounts for me, and they were able to. So the idea that we're hearing things that aren't them, by now we know well what weight drops sound like, and they correspond with the videotape. There's no weight drop policy, which we've heard so much about. We have video from last month. There's weight drops going on. That's what CrossFit is. You lift a lot of weight, and sometimes you get tired, and you drop that weight. And this flooring system they have doesn't work. We knew this 18 months ago. The only reason...
No, they didn't have this flooring system 18 months ago.
No, they had a prior
They just
one.
started working on it like 6 weeks ago.
Right, they had a defective floating floor system
Right,
back then.
right.
There was no attempt to change it until we got here, and it became clear that you weren't going to grant the permit unless they did something
Okay,
about
but
it.
we're trying to solve the problem,
And
so
we're
let's keep
on,
moving forward.
we are on board with that. You know, we have agreed to bring in a neutral expert under protocols that we'll agree to just take readings. Take readings, drop weights, see what comes back. And if it's quiet, great. You know, whatever they've done so far, there's been no formal testing of what they've done upstairs. No experts have been in, but we look forward to that testing. And if it's clear, it's clear. But you're going to hear from the unit owners today that for the last month and a half, the complaints have actually gone up quite a bit, and not at hours that construction goes on, 6 a.m., 6:30 a.m. This isn't times when people are doing construction work, neither the city nor our neighbors, but it is times when the gym is open. So rather than speak for them, I'll allow them to speak if it's okay with the
So
committee.
maybe one of the things that Sarami could do is be the expert that determines whether there are weight drops going on at the times of complaints, or whether maybe some kind of simultaneous observation of the gym for several days or something like that. I don't know if
Except
there's a way
they're
to.
closing tomorrow.
Right, oh, that's true, yeah. So, not sure how to work that, but during a testing period, then.
It's something we could certainly try to work out a protocol for. I mean, there's a video, so if we wire up apartments, you might be able to take a simultaneous video to audio log. Sure.
Yeah, but wait a second, are you?
I'm done. I was going to turn it over to the unit owners.
Okay, let's have finished with the speakers, and then you can respond, okay?
Ms. Gomes? Sue, did you want to speak? Yes. Sue Gomes?
Susan Gomes, apartment 2A, so we're right above the gym. Good to see you all again, I guess. I'm here, how many times now? I resent being here to some extent because it is taking my time, it is clearly still taking your time. And what's most frustrating to me is every time I am here, I listen to the gym owners tell you what they're not doing and what we're not hearing or why it's not them. I can tell you after 18 months, there is no doubt in our mind that when the floor shakes and our room is vibrating and we hear the thud and we feel it, we know what a weight drop is. And this is what we're feeling and this is what we're hearing. I was away on vacation for 10 days. I came back, and the minute I came in my apartment that evening, we heard it. We heard it the next morning. We heard it in the afternoon. It's on the weekends. It's all the time. It's not consistent. You don't know when it's going to be. but you feel it, you hear it, and you know it. I have lived in that building for 7 years. I was just speaking outside to my neighbors about how you never even hear a peep from the school behind us. It is not the school that's making this noise. It is not construction from next door that's on the east side of the building when I'm on the west side of the building. I am so tired of hearing the excuses and the misdirections. It's not them. Yeah, it is them. And I know what it feels like. And I am sorry that they have employees and they have people that want to work out. I feel for those people. But you know what? I feel for us in the building. And we have lived with this for 18 months. And like Mr. Ginsburg said, they didn't look to do anything with the floor until you were forcing them to. They didn't discuss doing anything with the drop ceiling until you forced their hand. They did not look to find a solution. From day one, JP tried to tell us that it wasn't him and that we were making shit up. Excuse my language, that was very inappropriate. That is very inappropriate. We weren't making it up. Then his partner came in and found out, no, we weren't making it up. But there was no discussion on how to fix anything until they were forced to do it. They're not looking to be good neighbors. If they were, then they would start with us, because we're their immediate neighbors. It's like trying to be a good family member, but messing up the immediate family. You start at home. And they didn't, and they haven't cared. And if they cared more, I don't even know how much they care about their employees. They're apparently independent contractors. I think they're more afraid of losing them to other gyms. And it's more about them. Once again, I don't think they're caring about anybody but themselves. Thank you.
Greg Loudermilk?
Hello, I think I've spoke with you guys before.
State your name, please.
Gregory Loudermilk. I live in 2C, so it's right above the gym. I'm a little offended about a comment that JP made that we're kind of making up these sounds or what they are. So on the 6th of February, right after they were told not to make any more noises, I was like, all right, I'm working nights. I'm going to start documenting this stuff. And I really went about it. It's a relentless sound. You almost want to give up. I mean, it just keeps going on, and it gets to the point where I'm just going to give up. And so I just kept documenting. So on the 6th of February, I heard these thuds, and I'm like, well, what is that sound? So I go out of the apartment into the trasher. Oh, I still hear it. I go all the way downstairs. Now, I've been going to the gym most of my life. I know what it sounds like to put weights on a bar. I also know what it sounds like to put the clips on the end. So I went all the way down to the basement where they have access to come through an emergency exit through our basement. And I could hear them putting the weights on, lifting them up, and dropping them. So I know for sure it was Brick lifting weights and dropping them. And I just kept documenting it and documenting it. It's disrupted our lives so much that we keep coming back to you guys, and we just need your support. And I hope that hopefully you guys are courageous enough that you can understand where we're coming from. We're not making it up. I really don't care if they're on the first floor or not. I go to the gym. I understand going to the gym. I just don't want the noise. That's all I want, is just not the noise to disrupt our lives. So thank you.
Thank you.
Anthony Yu?
Council, you don't need to introduce people. They can just.
Yeah.
Oh, okay, I'm sorry.
Good afternoon, Commissioner.
State your name.
Anthony Yu. I live in 2B between Sue Gomes and Greg Loudermilk. The building is on the north side of 17th Street. I'm on the north side of the building, so effectively facing nothingness. I have faced the school, and I'm between two other buildings. It is not the prettiest view that I have being on the second floor facing a building, but it affords me peace and quiet, or at least it did for 3.5 years. But I'd like to make 2 points. First is, I work, I think, from maybe 8 to 7. And so typically when I'm home is, let's say, before 7 o'clock and after 8 o'clock. So the observations that I typically note are not coming from the school. If you were in school, would you be at school at 8 o'clock? Probably not. To the east side of the building now is a room and board furniture store, not known for being extremely ruckus. And on the west side is, I believe, a Japanese restaurant and an alterations store and a yoga clinic, or gym or studio, whatever you call it. Again, not known for being extremely loud. So when we hear things, we kind of know where they come from. I will admit that compared to a year ago, the disturbances, the vibration, the thudding, I clearly am not going into brick. I don't know what it stems from, but it has gotten a little bit better. Instead of a metal hammer hitting wood, it's more like a mallet hitting wood. But nonetheless, it's still noticeable and awful. And, you know, a recent example is I had people over last Saturday, 6:30, and, you know, they notice it, they hear it. People who aren't, you know, worn down by it notice it. So it's still going on. Second quick point is a little bit of context. I think in terms of good faith and in terms of being a good neighbor, every time that I've been asked by the management company to allow people into my apartment, strangers, when no one is there, I always grant it immediately. I'm not there, what do I care? It happened, I believe, last week. Supposedly people are coming tomorrow as well. I think we've been extremely accommodating, and I remember, I think it was in the fall of 2013, there were original agreements between us and Brick, I believe, saying that weight dropping or kind of those types of activities would be limited to certain hours during the day. So not in the morning or not in the evening when people are either waking up or trying to have dinner with their families. And that wasn't stuck to. And so I think, you know, it's nice to hear we will, we're trying. But if I say that to my boss too many times, you know what, sorry, you need to put in your work. You need to actually like deliver results. And, you know, as the event, we haven't unfortunately gotten them. Thank you very much.
Thank you.
Anybody else?
Charles Rich, I'm, excuse me, Vice President of the Board of Managers. I want to just reiterate just quickly in the most basic data point way, March 14, March 13, March 11, March 10, March 9, March 8, March 6, 7. I won't read the rest. These are the emails I get from my neighbors. And I understand and appreciate that there can be other sounds, but I have to trust my neighbors at what they're experiencing, what we've all been living through. We've earned an education in a way we didn't want here. And I would speak specifically to the point about granting some sort of interim temporary PCE permit. My understanding of the law is quite clear that a gym is not supposed to operate without the permit. The gym's been operating since August of 2013. It seems, for whatever reason, I don't quite understand the process, that you all didn't get all the application materials till last July. We've been in front of the group, and to reiterate what my neighbor said earlier, is frankly only because of your diligence, intelligence, and desire to work and work and work were any of these items completed. The drop ceiling, the floor, it goes on and on. So I have nothing specifically to add other than that, but just to make it clear that the preliminary injunction only had one aspect of it, was the physical culture permit. There clearly are nuisance claims and specific prohibitions for other areas, so you're correct to ask those specific questions. Thank you.
Hello, Alan Firestein, Acoustalog. I don't know if what's going through your mind right now is the neighbors are saying the noises are coming from the gym, and the gym is saying they could be coming from elsewhere. But it's not that important because the new platform which they're working on is not implemented yet. So that's in the past. We're looking to the future. As you said, you want to get the problem solved. But I think it's important to keep in mind that the evidence that you've seen before you in the last year has shown you that a lot of steps have been taken, step by step, not all at the beginning, but as they were required, usually by you, such as the ceiling. I heard the statement earlier today that the mason floor that was put in was not designed for weight drops. It was designed for weight drops. It just didn't work.
No, that's what was said. It was a floating floor that failed, so
Yeah.
it doesn't work. Therefore, you have to treat it as something else.
Yeah, but you also heard from Mr. Koch several meetings ago that the dropped that the floating floor on springs with concrete is the best system possible. Okay. You heard that the springs are now, or the springs are correct. I don't know if I heard the word now, that people from Kinetics have come in and looked at the ceiling springs. I only looked at one spring. I opened it up. It was not correct. I don't know if they've seen that one or if it's since been corrected. But I'm just pointing this out in the overall context of what you're going to look at going forward when you see evidence that something has been corrected or not. Vibration readings look very impressive. You get all kinds of fancy graphs, all kinds of data. They mean virtually nothing. Taking a vibration reading on one point of a floor could be completely different from the reading up in an apartment. So again, everything you've heard about how the measurements done in the gym is not relevant is absolutely right. What's relevant is upstairs. The only thing I can add to where the noises are coming from now is that I have tested many times, and there has never been a situation where weights were dropped during our tests where I did not hear, feel, and measure sound or vibration, except once, and that was when they dropped on double thick pads in the basement. You've heard me say this a dozen times. There are accidents. I saw them myself with the instructors before we went upstairs to the apartment, not with ordinary patrons, where they drop off the platform. The boot camp that may not use barbells does not necessarily guarantee there won't be impact sounds, because I think that jumping on and off of boxes is a boot camp activity, and that makes impact sounds and vibration. And stacking up the boxes against a non-isolated wall, which they do, I told the owners of the gym they should really do something about that, because these are big wooden boxes about 2 feet by 2 feet by 2 feet, and they bang them against a sheetrock wall. They could put pads on the wall, big thick pad, that would solve that problem. I look back at the July 15th, 2014 hearing where I testified, and other people testified, and a member of the board stated, with regard to the noise code, this is after this whole thing about dBA being proffered as the way that the noise code measures, and one of you picked up correctly that, no, that's just an example of how the noise code deals with impact noise. The board stated that the noise code is not the standard that they are necessarily looking at. They're looking at the standard of no impact, no pun intended, on the residents, which might be a stricter standard than the noise code. So when we develop this protocol with a third party, I hope that they understand that that's what we're looking for. And I would urge you to not make a decision until you receive data that you can really trust, that's really relevant in the situation.
Thank you. Questions? Okay, thank you.
Martin Kelson, apartment 2D. Last time I was here, I spoke about a Saturday morning occurrence that was the vibrations and the sound. And then the people at Brick came up and very eloquently said that they weren't open, and then 2 days later, we found out that the videotape actually showed that someone was dropping weights. This is 2 years in the making. This is, I purchased the apartment, I think, April or May of 13. Jim moved in, and we've had noise and vibration ever since. Dropping weights is very different from dropping pots and pans, by the way. So in all transparency, when people lift weights, there's a certain amount of control. And if people are lifting 80 pounds or 90 pounds or 100 pounds, I go to the gym every day. I watch people lift weights, and I don't see anybody throwing weights. At my gym, coincidentally, are 3 or 4 trainers that are independent contractors at Derek Jeter Gym. They also work, and I'm sure that they're not employees receiving W-2s at Brick. They have some clients that they may train over at Brick. So when JP says employees, I own a business. I have independent contractors that receive 1099s, and then I have employees that receive W-2s. There's a very big difference. And independent contractors are usually in a well-communicated network. They will not be out of work. They'll go back to Derek Jeter Gym. They'll go over to Steel Gym. They'll be in 50 new gyms that are not making noise in the neighborhood. So when we truly hear and feel these weight drops, I guess the largest impact on my life is my child is up every day between 5:30 and 6:30. The vibrations wake him up. He comes to my bed. I have to put him back to bed. He's tired every day. He's tired every day going to school. I work at home. When I'm in New York, the weight drops are consistent throughout the day. I have people that come, some coordinators come to my apartment to work with me, and we just look at each other. What was that? What was that? It's not the people installing drywall at Twitter, and it's not the furniture moving around at Room and Board. Even when they loaded it in, they opened up a big 8x8 window, moved the furniture in, but they're movers. They weren't creating anything, they weren't putting up any block, nothing that would make noise. So the noise was coming from downstairs. I know that they've spent a lot of money, but they've only spent the money because you have insisted that they spend money in order to be good neighbors, good for the community. We're good for the community as well. I mean, it's an argument that now we've become the aggressor because, as JP very eloquently said, we're going to refute any claim that he has. Well, why is his investment more important than ours? And why, I'm not running the water in my shower and breaking the pipe so that it runs into his property. Why is he making noise and being a nuisance to my property? Been 2 years in the making. I was in California 2 weeks ago. I saw their building on Santa Monica Boulevard. It's a freestanding commercial building, which is where this gym should be, in a commercial building. How they ever thought that they should be in a residential building? I suppose if they purchased the apartments on the second floor, all this would be a moot point. And Anthony's received letters, I've received letters, maybe one every 3 weeks, one every 4 weeks to purchase my apartment. Seems strange. That's all. Thank you very much.
Any other speakers? Okay. Go ahead.
Chairman Perlmutter, I'll just be super quick because I'm sure you guys want to move on. First thing is, when I mentioned that we have 27 employees, that's outside of the independent contractors that we also have. So if they'd like to come in and audit the books and see what the actual numbers are as opposed to guessing how we operate, they're more than welcome to. All right. On that note, I also wanted to mention that when I was saying that these are not the standard plates that you see in a normal gym, that they are not. I didn't mean to come off aggressive. I just wanted to be very clear that we don't use steel plates as you would normally see in a regular gym. We use a specific plate that they call a bumper plate that is standard to our industry in size. So a 25-pound plate, if I were to hold it here in my hand, and a 35 and 45-pound plate would virtually look almost exactly the same. They do that for regulation of the sport and the different activities that we do with the particular plates, which is why even now when we're in a competition season, we have to submit videos. We have to do an actual close-up of the weight plates and the numbers that are on them, and at times even have to measure them because they're so similar everywhere from 10 to I know it sounds crazy based on the traditions that we're all used to in a normal gym, but we do not use steel plates. So clanking of weight plates, listening, behind a door could be, not saying that you're not hearing anything. It's possible that it's not the traditional noise that you're used to hearing because we use different materials.
What's the material of the plate?
Rubber. It's a high-density rubber plate. I could bring one in next time if we needed to. I also wanted to say that because Mr. Loudermilk and I have always had a great relationship through this, even though it's been rocky at times, I at no time was saying that he was making anything up, and I've no time said that they're all lying. This has never been a question of, I'm saying they're making it up, it's not us. I just wanted to make that clear. Also, the reason why Dave Koch would have said that the system that we put in was the best system available at that time, but it worked against the floor, even with multiple engineers being flown in from out of town. We didn't just assemble this thing overnight out of Legos. This was engineer requested, it was referred to us, it was designed, specialists came in from Ohio, and this is 2 years ago. So it wasn't like we just threw together a floor and hoped it worked. It's what we were promised and told for a very large amount of money would be the solve. Over time, here we are today. So again, going back to the drop, there's constant dropping even though we say we don't. In the video, it's also very easy because we wouldn't have submitted the videos if we thought we were lighting ourselves on fire. What they consider a drop and what is actually a drop are two different things. When you're taking a barbell and you're placing it from the waist level down onto a padded surface, that is not a drop. That is placing something down. If I am dropping it from the shoulders, that would be a drop. This we do not allow in the gym. Now, there are times on a video, as you had mentioned, it's kind of hard to see. At a wide distance, if I'm taking the bar and in its bar path, I am bringing it to my waist and then bringing it to the floor, could be perceived as a drop, even though I've controlled the weight at all times and I'm decelerating the drop. Again, we could sit here for days arguing back and forth. We know that at this point, what is going to be the best is having a third party that we've agreed on to come in and say, is this causing the nuisance or is it not? And if it's not, thumbs up, we can receive our permit and move forward and do good for the community. And if yes, we all know what the repercussions of the no, it's not working are. And that's obviously what we're working towards. So I just wanted to make those clear, and I want the building to understand that I'm never coming up here saying they're lying. All right, but just as they come up and they state their things as their facts, I have to do the same for mine based on what we both parties believe in. All right? If there's any other questions while I'm here, I can answer them for you.
Well, even if you do bring in a third party, you had your own consultant at one point show that with the existing floor you were using, that there was vibration upstairs. So I would say, irrespective of what the third party says, you do have a vibration problem without installing some special flooring.
Yes, ma'am.
Right, so they know that, yeah.
Yes, ma'am. We know this.
All right.
For certain.
Okay,
Thank
you.
Frank Angelino. On the record, it was mentioned this is a residential building. How is a physical culture establishment able to apply within this zone? As you know,
I don't think
it's a
that's what-
C6 zone.
That's not what they said. They said they wonder why Brick that has a separate building in Santa Monica would think of having a brick gym in a residential building.
Yeah, because this is New York, and we don't have single-story buildings all over the place like Santa Monica. If you like Santa Monica, you move to Santa Monica. I think the testimony, I think the testimony that was given couldn't have been more eloquent to make the case that they want brick out. And if with the board's permission, I'd like to put a case to you. I'd like you to put the case that you four commissioners own an apartment on the second floor of a building which has a first floor condominium where there is a gym, a physical culture establishment. I'd like to put the case that you are renovating your apartment completely down to the bare walls. And I'd like to put the case and ask you whether or not, in all prudence, knowing there is a gym below you, you would have put some sound attenuation material, since that's very inexpensive while you're doing construction, and that you could have eliminated at least to your mind, the most that you could have done on your end to prevent sound. I'm giving you an actual instance of where in this building that took place. If you say that, well, it's not reasonable for us to put any sound attenuation measures, it's the gym's responsibility, we want them out. I'd like to put the case further to you, that suppose the gym came to your attorney and asked him whether or not you, the gym, could put the sound attenuation measure while this apartment is being reconstructed and is vacant for a number of months. And I'd like to put the case to you that the answer coming back from the attorney for the residential condominium is no, you can't put in any sound attenuation because basically we want you out. And I think the testimony you heard today and that case, if it's fairly answered, tells you they want them out. What we've been trying to do with adopting the suggestions of the board, and a lot of these things were started before we got before the board, but what we're trying to do is solve the problem. As I stated in the first hearing in July, we're trying to make it a win-win situation. Unfortunately, we're in a situation where the opposing party is trying to make it a win-win only for one side. So we ask the board's consideration as we move forward in this very difficult period for the gym on the request that was made by Jared Perlmutter in good faith. We also we are grateful to the fact that the board made the suggestion of an independent third party, their suggested third party, that will use, and with a protocol that will be drawn up between the two attorneys and going forward, or all attorneys going forward, on how that third party will view anything. I think you've heard from Acoustalog. I didn't know that Acoustalog was also an advocate and an attorney. I thought they were, like Mr. Koch, an engineer. But you've heard from them today advocating not a solution, but putting up obstacles to a solution. We want a solution. We want to have Cerami in to make that solution.
I'm sorry, I must be hearing different things. All I'm getting is that the gym installed this incredibly expensive ceiling, and that Acoustalog observed some defects in the ceiling, and one of which I understand from Criterion, passed the manufacturer's inspection, but on the other hand, there's this issue with the spring, and it seems to me if I spent, I don't know which number of hundreds of thousands on a ceiling, I would want the contractor to be sure that it's installed properly, and I wouldn't want to put up sort of ego battles between which expert is a better expert. I, owner, would just want the ceiling installed properly because I paid a lot of money for it. So that's kind of, if all of the experts say there's a defect in the ceiling, fix the defect in the ceiling and don't have a debate about it. And then the other one was about the boxes that I've only heard about, but not in this hearing, but in other situations. And so if the boxes are a source of banging against the wall, then I thought that was a reasonable suggestion. Put padding against the wall so the boxes don't become yet another source. I hear that as suggestions to reduce nuisance, not as a lawyer battling it out to be the winner.
Well, let me respond.
Okay.
When Acoustalog came in, apparently they wandered into the gym and started poking around. That wasn't done having Criterion Acoustics together with them to say, let's solve the problem. It was to find details, punch list items, as it turned out, that were already on Mr. Koch's list for curing. So they weren't coming in to solve the problem. They were coming in to make testimony against the gym.
Okay, so
So
now
we're trying to solve the problem.
Yeah, so try to solve the problem, stop, hair splitting and all that. Just make sure the
We're not trying to hair
installations are done properly, and that this third consultant is the one who breaks the tie and gets this done properly, and listen to the recommendations of the experts.
Chair Perlmutter. The pad for the wall for the boxes was already purchased. So by the time we reopen the upstairs, it'll already be in place.
There you go, okay.
Yeah, and virtually every referral that Mr. Firestein has given me directly, we've put in place almost immediately.
Except for only doing weight drops in the cellar.
We have not been doing any weight drops.
No, in terms of planning your layout so that you only do weight drops in the cellar.
Right, we've actually created a protocol within the gym where we don't do any scheduled weight dropping at all.
Well, what you call, depending upon what the height is, whatever is causing the vibration, that it's not, that it's only done in the cellar.
For instance, all your weight lifting could be done in the cellar arguably. Like if
That's
all
right.
your racks are in the cellar and only yoga and I don't know what else is done upstairs, maybe this would cure the problem.
Well, that's what we're prepping the entire area for anyways. So we are already taking Firestein's recommendation of building the platforms in the cellar.
Okay.
They're already ready to go once we open the main floor up, and we'll be moving all of that heavier lifting into the cellar level. We still need to take the means to absolve the sound issue upstairs if they're utilizing a box or even just walking around. That's how hypersensitive the area is. So these are the means in good faith to do everything we can, even though we have already made the decision to move all of that into the cellar level and build the platforms.
So if you're doing that, then we should be receiving plans that show the activities and how they're laid out. Because if you're moving all the lifting to the cellar, and even Acoustalog said that they didn't hear the weight drop that was on a pad in the cellar, maybe that potentially cures the weight lifting issue in the gym. And if all the sort of relatively normal gym activities occur, I mean, if this was a gym with like treadmills or things like that, it would be going through sort of normal acoustical measures, right?
Well, we're moving that direction anyways.
Okay.
So much of the equipment, we are bringing in some of those standard cardio-based equipment ideas to move the culture of the gym away, which we've already switched completely. So although in our legal doing business name, you hear the word CrossFit, we are not traditionally, we teach CrossFit. We are not a traditional CrossFit gym. It is not it's not the sole purpose of how we function, and it does not make up the bulk of all of our classes. That is the truth.
So all that kind of operational stuff, you should get in writing, so we
Yeah.
understand.
Yes, ma'am.
Okay, just clarification. So you're planning on moving all of the weight drops or the weight equipment? Let's be really precise here. I realize we got to be really precise. So all weight equipment will be moved to the cellar? So then if that's the case, why are you even doing work on a level that is not the cellar?
What we're doing, the concern here is the weights that really go into the realm of 135 pounds plus.
So it would be heavier weights would be moved to the cellar. You aren't moving all weight activity to the cellar.
No, that would be incorrect. We are moving, yes, you are correct. The statement would be incorrect to say that we're not doing any weight use, because all exercise has some sort of engaged weight use, whether it be a 40-pound.
Just to be clear, because it sounded like all weight
Right.
activity was being moved to the cellar, but in case that is not the case.
All of the heavy barbell activity, anything that we've tested that has proven even prior to be successful, is what we would maintain in the mid-level.
So what constitutes heavy weights?
Virtually anything over 135, we've found that 115 below. But so let me be clear here. What you will see in the protocol, and however else we can provide this material for you so you can understand, is that anything greater than 115 pounds, so we're going to give ourselves that 20-pound security blanket, nothing in that realm will ever be utilized on that main cellar level, on the main floor level. That will all be moved downstairs. So any of the classes that would generally promote a heavier weight will not be on that main level. You'll see that in our materials, you'll see that in the class scheduling. You can see it by requested regular video submissions. We will do whatever it takes to prove that we have made the necessary adjustments, not just by the means of the floor, even for the med balls, the boxes, and all these other things, but we've also taken these scheduled protocols of the workouts and moved them downstairs.
So everything over 115 pounds is downstairs. Anything above 115 pounds is on your main level, And so when we're looking at photographs of these racks, et cetera, that appear to be on the main level, because I'm looking at windows,
Yes.
those racks only are for weights that are under 115 pounds.
Yes, and
This floor is then designed to only take 115 pound?
no,
Or it's
we're security blanketing
over-designed?
this thing to the hilt. And I also want you to understand that those racks do have other purposes outside of just lifting weights. We do pull-ups and plyometrics and all types of different gymnastics, body weight-based movements on them. So they're not, the sole purpose is just not for weights, although that's how they look.
Okay, so you'll give us a plan and an updated operational
Yes,
plan
ma'am.
as well as a physical drawing showing us where all this stuff happens?
Yes, ma'am. I want to make that clear. We made the decision long ago, as we slowly evolved, to change the protocol and the culture of the gym to separate that out and be able to clearly define ourselves away from a traditional CrossFit gym that engages in heavy load movements.
Okay, I just wanted to make sure I was hearing you correctly.
Yes, ma'am.
Okay. So. Don't know. Do we hear from you again? When? Do we hear from you again at the end of April? I mean, go ahead.
I would recommend to the board, if they were interested in this course of action, allowing them to install what they need to install, have the testing done, let the third party do its review, and then they can brief their positions on the matter, and then this board can review whether or not they think this gym can operate in this building. The findings can be made.
So that could be a while, installing all that stuff. Because we also haven't seen we haven't seen the details, which we commented on before. You could submit I mean, I think that's what we did with the ceiling, was they submitted details and we had comments.
Well, it's also the revised layout of the gym.
Right.
And any testing has to sort of comply with what they intend to do in that location.
Right. So I actually don't think we're at the point where there's like a final submission. It's more, it's like an interim submission. Whether or not we actually need a hearing is another subject. But how about this? We set up maybe we could adjourn it. Maybe we set up a potential for a hearing on, say, April 28th. I don't know if that's enough time, though. You have to engage Sarami. It's not enough time. You have to engage Sarami. You have to provide the plans to show the layout of the proposed work and the operational plan, what kind of stuff is going to go on. Sarami has to have done its analysis of the proposed installation and of the existing installations. And that's what we need to see.
Have you retained Strong already?
No, in a few days, they said.
We just got the answer. We made the request a while ago. We just got the answer back today. And I guess it's because of the hearing that we got the answer back. But as I understand it, we could retain them fairly quickly. Is that correct, Jared? Dave? They'll be retained immediately.
Okay, so then,
Yeah, we can meet that schedule.
okay. Okay, so if you come here on the 28th, we would need to see a submission at least by the 14th. I don't know, that's only 2 weeks. Seriously, you could do that?
You have to have Sarami on board to be
You have
able
to have
do that.
Sarami on board to do all the testing, all the analysis, the drawings modified, all that stuff in 2 weeks.
Outside Cerami delays on our part.
Yeah, but I don't know.
Yeah, but it's Sarami that we're.
They want Cerami.
Passover's coming next week, which is.
Right.
But we're gonna have it for these past schedule.
Well, but there's a week after, if there's a hearing on the 28th, there's time to respond if you submit on the 14th. Right? Otherwise, we'll just keep moving it out. I mean, that's your business. We could also make this for the May 12th.
What date?
Okay, so let's do this for May 12th with a submission on, say, April 30th by you and by the, what gives it a week? The 7th by opposition.
Okay, thank you.
Okay. I think do we have anything long now, or?
We have an adjournment.
We have an adjournment, and then after?
We have the Garfinkel.
Garfinkel,
I don't even see
Right.
and then the
Garfinkel's.
Just a
PCE.
couple.
The adjournment and Kramer 11, and then the PCE.
Okay, we can continue then.
Yes.
All right.
Want to do those?
Yeah.
Okay. Item number 21, 5914BZ, 114, 122 Jackson Street, Brooklyn.
Okay, I don't know if anyone's here. They requested an adjournment to the 28th of April. That would require a submission on the 9th of April with opposition on the 16th of April.
Item number 22, 12214BZ, 1318 East 28th Street, Brooklyn.
Good afternoon, my name is Monica Mbakwan. I'm here representing Garfinkel Architects.
Okay. I think we were okay with this and its modifications, so we could close this. So for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Thank you.
Thank you very much.
Decision date?
Oh, sorry. So, everybody gets
Blood
so
sugar is
fast.
plummeting.
It totally is. I could not even see the calendar. So that's for decision on the 14th.
Thank you.
Item number 23,
You think we could
238.
Grant? Could we do a closed grant?
Yeah, sure.
Can we do that? Oh, wait, stop, come back, come. Yes, we can do a grant. We don't have objection from council who has to write the resolutions.
No.
I usually defer to them because they have to write the resolutions.
So what do we do?
So
Let's do
for a
it.
motion to grant.
Oh, so you're not, oh,
Yeah.
Yeah, it was a possible closing grant.
okay. So Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
This is granted.
There you go. One less thing. Okay.
There we go.
Thank you very much.
Please.
Item number 23, 23814BZ, 9800 Franklin Street, Manhattan. We have adjournment request of April 21st.
Yeah, to 421 with, I heard that the submission was already made, so they would need to have made it, so,
We're keeping him awake.
okay.
Item number 20, go on. Item number 24, 24114BZ, 517 East 117th Street, Manhattan.
Good afternoon, Josh Rhinesmith for the applicant.
I think we have everything on this, so for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Can we do a grant? Just PC, normal PC.
Chair
Not to be
Perlmutter?
confused.
Wait, are any speakers? I mean,
Oh, are there any speakers before we?
no, okay, fine.
Okay.
Chair
for-
Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
This is granted.
Thank you.
Thank you very much.
Okay, we're gonna resume at one, we're gonna
Yes.
resume at what?
Take a 1 minute break.
No, at 1:20 or, I guess, 1:30.
1:30 for the afternoon cases, sorry.
Bacon.
Gotta go right now.
Right.
Camera, camera, camera. Your mics are still on, turn your mics off? Still hot?
What are we going to say?
Such a